Your name?
Robert Thomas Boyd.
Before we go on, I'll be happy to provide you with a lawyer if you want. This is a review hearing.
No, sir.
You waive your right to a lawyer.
I do.
Name?
Caitlin Porter, Henry Constance Township.
Rob Harris, Inspector Brown South Township.
Please tell me he did what I told him to do.
As of yesterday at about 2 p.m., no,
Nothing?
nothing. The property looks worse.
You're gonna force me to do something I don't want to do, Mr. Boyd.
I've done a lot of work out there. I've,
Okay, let me just go through this with you then. Okay? I ordered that the garage must be torn down and removed from the property on or before September 15, 25. And the undersurface filled to grade level. Did you do that?
no,
I ordered that all non-permitted accessory structures be removed from the property. Did you do that?
what structure would that be?
Remind me.
It's like the mobile home.
Right.
And use as storage.
Rob was supposed to give me a phone number, a place that takes RV.
Why don't you tell me what you've done? I ordered you to have all vehicles on the property licensed and operable, and that they had to be located on a concrete or asphalt driveway surface. When I read these to you, you can interrupt me. You can stop me and say, Judge, I did that. Did you do that one?
No, sir.
I also said all inoperable vehicles have to be stored inside an enclosed building or removed from the property on or before October 1. Did you do that?
Partially.
I also ordered that all recreational vehicles have to be operable as well as licensed and registered to the owner or occupant of the property. Did you do that?
Yes, sir.
Did he?
I have no proof of that. I've called for an inspection, no return call, no nothing. I had never.
Recreational vehicles must be stored on hard or pervious concrete, asphalt, permeable grass pavers, or gravel surface. Recreational vehicles have to be used for their intended purpose and not as storage. Winter boat storage is only permitted on residential waterfront surfaces and therefore not permitted at the property. Junk, trash, rubbish, tarps, anything that creates rodent harborage or refuse of any kind needs to be removed. The weeds, grass, and undergrowth must be cut and maintained so as not to be higher than 8 inches. And I also ordered that prior to the review hearing of actually today or September 26th, I said, defendant is to permit Brownstown officials on the property for a compliance inspection. Did you allow them? Did you call there?
Yeah.
Did he call you and he never called you back? Why didn't you do that?
Didn't get it.
Listen, Mr. Boyd,
There are some circumstances here I'd like to tell you about.
Mr. Boyd, I'm going to listen to you. But it's not like this just started. This has been going on for, as I understand it, how long?
Well, there's opens for over a couple of years, and then I took it on like at least 8 months ago.
And the property's getting worse. I went out there. I didn't want to touch anything. I want to listen to what you have to say. I'm going to shut up and let you talk. Tell me whatever you'd like to tell me.
Well, I'm chairman of the Wayne County Canvassing Committee. We had an election. That was 2 weeks. Every day. When you have election, birthdays don't count, holidays don't count. We have to be there every day for 2 weeks.
When was that?
It was a Trying to think of the date.
Well, 2 weeks, but I ordered this.
Yeah, well,
I ordered this back on July 30. This is September. So since July 30, just to do some quick math for you, we've had 32, we've had 56 days. So even if you were tied up in some kind of an election, for 14 of those, you still had 42 days.
yeah.
What else? What else? I want to listen to your extenuating
I
circumstances.
had a family reunion that was put on me and I didn't know about.
Mr. Boyd,
That was 14, 4 days.
you've had 2 years. The property's junk.
I'm working on it.
No, you're not.
Yes, I am.
That'd be like, no, you're
I
not.
got the boat out for sale up near the road. I got,
Now you're gonna tell me it's bad weather and you can't do this stuff. I don't know what to do with him. I'm gonna be completely candid. I don't know what to do. Because he's not gonna listen. He's not gonna comply with the orders. He's not defiant. No, you're not. No, no. Oh, you're not. You're not gonna comply with orders. You're gonna give me every excuse under the sun. And this can't go on. It just can't go on. And you're gonna force me to put you in jail today. And I don't want to do that.
I don't want to go.
I feel like I've begged you to do these things and you're not doing them. And then last time I got a little more forceful and I ordered you to do it and you haven't done anything.
I'm working this.
No, you're not. Mm-mm. No, you're not. Come on. Don't lie to me.
I'm
I
not,
don't like people that lie to me. I think there's nothing worse than a person that stands in the courtroom and looks a judge in the eye and lies to them. This is, I don't know what to do with you. I don't know what to do with you other than jail you, because I'm not going to get your attention. You're going to give me every excuse under the sun. Reunions, elections, 2-week election for a canvas presidency or whatever you.
every election is 14 days.
I just don't know what to do with him anymore. It's fully Carter. Am I supposed to put him in jail or am I supposed to just let him defy orders? That's basically my options here.
I am working on it.
Why didn't you call him back?
Pardon? Oh, I didn't get,
Why didn't you call him back?
I didn't get it. I didn't get his call.
Did you leave a message? When?
It's been probably 3-4 weeks, but I've been out to the property. I mean, I drive by it probably at least twice weekly. There's been no.
I knew this was going to happen.
It doesn't work.
I knew this was going to happen. I just knew this was going to happen. I was 1000% positive that this is what was going to happen. And I was going to have to sit here now and decide, do I let in gentlemen like Mr. Boyd, you are a gentleman, defy orders repeatedly, or do I send you to jail? And I don't think I have an option.
I need more time.
You're going to serve 5 days jail starting today, sir. It's first technical. I'm sorry, that's what I'm doing. Lieutenant to serve 5 days jail forthwith. And
Hard to do any work from jail.
listen, I'm going to make a promise to you. You do this again, you're going to be sitting in there over Christmas. I promise you. I'm not playing games with you. That's a junkyard. You have neighbors. They don't need to have that blight by their house. My God, who would buy a house anywhere near there? I don't know what else to do. You're in custody for 5 days. Good luck. We're going to set another review. Lisa, give me another review hearing date in a month. If you don't have it done, sir, I'm telling you, bring your toothbrush and 85 pairs of clean underwear. Do we understand one another?
I do.
Good. Okay, new review hearing date, and you're gonna allow him access too the minute he's out. The minute you're out, you answer his phone calls. I'm sorry, Lisa, go ahead.
October 22nd at 8:30.
October 22nd at 8:30.
Yeah, before, can I just double check what Mr. Boyd's phone number is?
What is your phone number, Mr. Boyd?
734-274-4336.
I don't know what else to do.
My concern is, Mr. Boyd's had problems with ordinance since I was in middle school, as far as I'm concerned. This continues to happen. This citation was issued back in April. We've been running around with this. It's not only the neighbors and the blight issue, it's also the dangerousness of the building, especially that garage. He hasn't taken out any permits or anything of that nature, so he's had no intention to comply.
No, I've just heard excuse after excuse.
Gotta have a permit.
And I knew.
Demolition permit, but you have to at least have the building inspector out there to make sure that the structure can come down, if there's electricity there and what the plan is. So you can't just demolish it and have everything sit there. So that you'd have to have a plan at least at minimal, approved by the building inspector for any demolition.
But he told me that.
Mr. Boyd, listen. You brought this on yourself. I don't want to do this.
And he never informed me about that.
I know, it's their fault. I don't want to hear it.
Judge.
You gentlemen have a case ready. What's your name, sir? I'm sorry? Okay.
Yeah, he's a problem with the town.
Hopefully. J. Edward Clay. 25I-76087C.
Yes, sir. I believe it, sir.
Your name?
J. Edward Clay.
Were you here on September 10th as well?
Yes.
So we adjourned it. I thought you guys were going to have a resolution, but you didn't resolve it?
No, sir. There's a couple of entities involved, my homeowner's insurance. They wanted me to, make something, the homeowner's insurance told me just to hold on and get another lawyer so I could work with that work. So I contacted the Bar Law Association, and they're supposed to be getting back with me the next day or two.
Okay, I want to be clear. I'm adjourning this 2 weeks. You're going to have a lawyer, okay?
That's fine. I just,
Adjourned?
time was taken.
Sure enough.
I didn't know it was that hard to like get a response.
October 8th, Lisa?
Yes, October 8th at 10.
Okay, sir. October 8th at 10. You can go down the hall. We're going to have a formal hearing of the date. The notice will be handed to you. October 8th at 10. Okay,
Fine.
thank you. Has Mr. Barbie met with Ms. Foley Carter yet?
That's a Groziel case, but yes, he met with the prosecutor.
Okay.
Hello?
Hi, did you guys talk to Mr. Barbie yet? And do you have a file to bring in to me?
Yes, Your Honor. Second. I'll We'll send it in right away, Your Honor.
Thank you.
Thank you.
In civil contempt, you don't necessarily have a right to have an attorney to represent you. You certainly can hire one. There's not incarceration possible as a punishment for civil contempt. There is a fine of up to $7,500 and other equitable relief, meaning the court can order that certain things happen. But if you're found in contempt, you're not subject to incarceration, at least not for this hearing. And the burden of proof is lower in civil contempt than it is in criminal contempt. It's a burden of preponderance of evidence. But essentially, the allegation is the judge ordered back in March that you not do certain things and that you continue to do them. So the township filed an order to show cause. You didn't appear for the show cause. There was a bench warrant. You came in and we took care of the bench warrants. And now you're here so we can proceed. All right. Thank you. Anything further? No, Your Honor. All right. The township may call their first witness. That I would call Joanne Yoder, Your Honor. Ms. Yoder, would you come up into the witness box? In civil contempt, you do not have a right to not testify. If you're charged in a criminal case, you have an absolute right not to testify. In a civil case, you don't have that right, and you're subject to being called by the opposing party. So Ms. Yoder, would you come up here in the witness box, and then we'll see how we can proceed. Good morning. Would you state your name?
Joe.
All right, have a seat if you would. I know that Amish don't like to swear out an oath, so would you be willing to affirm that any testimony you will give here today will be truthful to the best of your knowledge and belief?
Under God, I testify.
All right, do you hereby affirm, not swear an oath, but affirm that any testimony you give here will be true to the best of your knowledge and belief?
Yes, sir.
All right. Affirm. All right, Mr. Thornton, you may inquire. Mrs. Yoder, if you could try to speak up so that the proceedings are being recorded and so that I can also hear and everyone in the courtroom can hear your responses. Okay. Mrs. Yoder, where do you live? Where's your residence? Yes.
I do have a problem with my mind does not work in groups of people. Is sometimes coming up with answers and to respond. So please excuse me if I cannot.
All right. Well, let's see what we can do. Do you live in Colon Township?
Yes, sir.
All right. Do you live on Marsh Road?
Yes, sir.
What's the number of the house?
30158. Actually, I have two addresses that I get lumps of two.
All right.
30101 and 30158.
30100.
Yes.
Okay. Thank you. And it's no fun to sit in a witness box. I've done it myself. I've had little small children in the witness box. But let's just try to do the best we can here. In following up, Mrs. Yoder, with the two addresses you've confirmed on Marsh Road, the 30158 Marsh Road, is that your home that you actually reside in?
Yes.
And then the 30100 Marsh Road, that is a second structure on the same parcel as your home, is that correct?
Yes, sir.
And that was built as a home, is that correct? That second structure?
Yes.
And those two, your home that you reside in and this second structure are on the same parcel of property, is that correct?
Repeat.
The two homes are on the same tax parcel? And you operate a birthing center in that second structure, is that correct?
No.
And what happens in that second structure? Is it empty? Is it occupied? Who occupies it? Can you tell us a little bit about that?
It's a private ministry.
Okay. Can you elaborate on that? What do you mean by private ministry?
That's what we have as a private ministry.
Are there births occurring in that home?
It's a private ministry.
That's not my question. I'm asking you, do pregnant women give births in that second structure on that parcel?
My understanding, it doesn't matter what we do in our ministry.
Well, that may be your opinion. We'll determine that. Right now, we're just trying to establish what happens. And so you are required to answer the question.
That is part of it. But it's a private ministry.
So it would be accurate to say that the structure is used partly for pregnant women to reside there temporarily and give birth.
Yes.
With the assistance of a midwife.
Yes.
And this this birthing, the use of that structure for births Did you used to call that Mama's House Birth Center?
No, sir.
You never called it that?
No.
Did you have a name for it? Or do you have a name for it?
We do now, or we did have
Okay. What's the name now?
Mama's House Ministry,
Was there a prior name?
Mama's House Birthing Center,
Okay. When did that change?
February 6th, when you had received all the documents of the change.
I missed it. February.
February 6th, 2025.
Okay.
And you received all that. We had given you the documents on that. That was recorded here at the courthouse.
My understanding, you had a DBA. Is that correct? Doing business as name?
Yes,
Okay. And so if I'm correct, it used to be before February 6, 2025, Mama's House Birthing Center.
it's,
And then after February 6, 2025, you changed the name to Mama's House Ministry.
it's,
Has the important date here on my next few questions is going to be March 13 of this year, March 13 of 2025. Because that is the date that the default judgment and permanent injunction entered by the court. So let me start there. You did receive a copy of the default judgment and permanent injunction, correct?
I think you said,
And after that default judgment and permanent injunction entered on March 13, 2025, did you continue to allow pregnant women to temporarily reside at the 30100 Marsh Road for the purpose of giving birth to their child?
yes, Your Honor.
Approximately how many births occur there in a week's time?
It varies.
What does it vary from? What would be the low? What would be the high?
What is the necessity of this?
Well, I'm interested too. I don't know if they're having one birth a month or 6 births a week. So I'm trying to get a sense of it. Bear in mind, I didn't start this case. Judge Stutzman's heard some things that I have not. So I'd like to know the answer to that myself.
Probably approximately between like 4 or 5 per week.
As an average. Would that be the case prior to March 13 of 2025?
Probably.
And would that be the case after March 13 of 2025?
Probably. Your Honor,
Yes.
may I speak for this before we go further?
Well, yes, what would you
So-
like to say?
The first court hearing, what he's talking about was all about Mama's House Burden Center. And there was, I've got proof here where that was all dissolved.
And so now it's Mama's House Ministry?
So that court hearing, what, everything that they run through was all a default because there was no such thing.
I'll make a note of that. Let me briefly respond, Your Honor. Yes. As part of this case, it's not the DBA that's the defendant, and it wouldn't be the DBA that would be the defendant. It's actually Alfred E. Yoder and Joanne Yoder individually as owners of the property that were made the defendants of this case and that were ordered not to allow the birthing center to continue on the property. So yeah, I guess it's the township's position that the change of DBA is irrelevant. All right.
And Your Honor, then the next thing also. So we received paperwork on the hearing, and in that paperwork, there's nowhere that it gave us to shut down. It says as soon as convenient, and that's not an appropriate time because it was never convenient.
All right, well, we'll explore that. So the births that have occurred and are still occurring out there after March 13, 2025, a midwife assists with those births. Is that correct? You have to verbalize your answer.
Yes,
Are some of the women giving birth there on the property we're talking about after March 13, 2025? Are some of them unrelated to you?
yes. They're part of our ministry.
But they're not a blood relative or a relative by marriage.
Some and some not.
Some are, some aren't.
Yes.
After March 13, 2025, are you charging the pregnant women that have birth there any fees for being allowed to use your property?
They donate.
They donate.
Some pay, some don't.
Do you have a established donation or a suggested donation?
Suggested.
Okay, what is that?
It's according to how much, I guess how long they stay.
Or kind of based on length of stay then?
So,
So is it like a room rental fee?
yes, Your Honor.
Do you have any other fees or suggested donations for the pregnant women that come there to have birth, such as maybe for meals or things like that?
No,
So that's included in the other donation you testified about.
no money for food.
I didn't catch that.
There's no money for food.
Okay. So the room rental you do accept.
Yes, Your Honor.
When there is a birth there, and again, I just want to concentrate now on after March 13, 2025. When there is a birth there, are you required to do any reporting as the owner of the property?
No,
So you're not required to report that a birth has occurred.
they have to have their documents for a birth certificate, that's all.
Okay, and that's what I'm referring to. So who prepares the documents that are necessary when a birth occurs on your property?
Midwives.
Do you have anything to do with that?
I have a midwife.
Okay, so would it be accurate to say you prepare some of those reports?
Yes, I do prepare some of the reports.
Okay, and where do those, and these are reports of the mother's name? Is that correct?
Yes,
The name given to the child,
yes,
the date of the birth, is that accurate?
Just to fill out a birth worksheet.
Okay, so anything on that worksheet, you fill out or another midwife fills out, correct?
Yes,
Where do those reports then go?
Here.
Here, meaning to the courthouse?
yes,
Would it be accurate to say they go to the county clerk's office here at the courthouse?
yes.
And how often do you make those reports?
Just whenever we have a birth.
Within hours or days, how often after you have a birth do you make that report and submit it?
We aim to have it done within 5 days.
You deliver those reports to the courthouse by hand, in person, or do you mail them to the courthouse, or is it a combination?
Both.
Both? If I were to indicate that there's been approximately 87 births on your property that we've been discussing here, that has the two common addresses of 30158 and 30100 Marsh Road. If I were to say that there's been approximately 87 births since March 13 of 2025, would you think that would be roughly accurate?
I have no idea.
Does it sound way too low, way too high?
Guess I don't keep track. I don't know.
Can you tell the court why you are continuing to allow pregnant women to temporarily reside on your property and give birth to children in contradiction to the default judgment that entered in this case?
Well, number one thing, because the first court hearing was not appropriate. And number two, Section 28 of that Michigan Constitution, I know you don't like it, you threw it in the trash. Section 28, right to productive freedom. Section 20, every individual has a fundamental right to reproductive freedom, which essentials the right to make and effectuate decisions about all matters relating to pregnancy, including but not limited to prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. An individual's right to reproductive freedom shall not be denied, burdened, or infringed upon unless justified by compelling state interest achieved by the least restrictive means. Notwithstanding the above, the state may regulate the provision of abortion care after fetal viability, and provided that in no circumstances shall the state prohibit an abortion that in the professional judgment of an attending health care professional is medically indicated to protect the life or physical or mental health of a pregnant individual. The state shall not discriminate in the protection or enforcement of this fundamental right. The state shall not penalize, persecute, or otherwise take adverse action against an individual based on their actual potential perceived or alleged pregnancy outcomes, including but not limited to miscarriage, stillborn, a birth, or abortion, nor shall the state penalize, prosecute, or otherwise take adverse action against someone for aiding or assisting a pregnant individual in exercising their right to reproductive freedom with their voluntary consent. For the purposes of this section, a state interest in compelling only if it is for the limited purpose of protecting the health of an individual seeking care, consistent with accepted clinical standards of practice and evidence-based medicine, and does not infringe on the individual's animus decision-making. Fetal viability means the point in pregnancy when, in the professional judgment of an attending health care professional and based on the particular facts of the case, there is a significant likelihood of the fetus sustained survival outside the uterus without the application of extraordinary medical measures. This section shall be self-executing, not provision of this section held invalid shall be servable from the remaining portion of this section. Michigan State Constitution.
And just to clarify, Mrs. Yoder, it's not that I don't like the Michigan Constitution or the US Constitution. I have a ton of respect for both. I just don't need to be provided a copy. I have copies of both and access to them. So
Very appropriate.
So if I want to read you paragraph 3 of the default judgment. The defendants and their agents, servants, assigns, and successors in interest, and or anyone in active concert or participation with the Yoders with regard to the operation of the birthing center are permanently enjoined from operating a birthing center on the Yoder property. Do you feel you're violating that paragraph of the order by continuing to allow pregnant women to come there and have births?
No, I do not.
Has anything changed?
Let me stop you for a moment.
Okay.
Paragraph 2 precedes paragraph 3, but she brought this up. Paragraph 2 states, Colon Township's request for injunctive relief is granted, and the defendants shall cease operation of the birthing center on the Yoder property as soon as reasonably possible. I think that had to do with perhaps you had clients that were in the process and you didn't want to immediately close it to leave some of those women with no prenatal care and no option for birthing except as emergency basis. Well, that was March. It's now September. And what you stated earlier is it isn't reasonably possible or won't be. Is that part of your argument too, that it isn't as soon as reasonably possible as of March 13th? How do you interpret that? And bear in mind, this is before I got here. Judge Stutzman ordered, stop doing this. The request for injunctive relief is granted, meaning no more operation of a birthing center on that property. And you're to stop as soon as reasonably possible. And paragraph 3 makes that injunction permanent from operating a birthing center on that property. So there may be some interpretation about what is reasonably, as soon as reasonably possible. I'm sure it's somewhere between March 13th and September 24th. Do you know when the last child was born there? How recently did you have a birth?
Your Honor, we made an agreement and I followed the 10 Commandments.
Has there been a birth there in the month of September?
Because I don't remember the date that we was here. We made an agreement.
Agreement with God or with who?
To not have a birth there
All
until
right.
today.
Okay, so you don't right now know when the last birth was?
No, I did not.
Was it within the last 2 weeks?
Or whatever it was that we was here, that we made an agreement. That date was.
I'm not sure which date that is.
I think she was talking about the date of the unscheduled hearing
Okay, when they,
when they were here at the courthouse and Your Honor
and
contacted
that
them.
was August 29th. So you're saying there haven't been any births since August 29th?
Not there at that address.
Okay.
Just to follow up on Your Honor's questions, how long is the normal stay of a pregnant woman that comes there to have a child?
Not more than 3 days.
And how long before they actually come there do they normally contact you and make arrangements to stay?
Well, that can vary on how you are, what you're after as far as when they realize they're pregnant or when they're in labor. That can be 9 months, or are you considering on when they start labor?
I'm trying to get at, when do you schedule them to be at your property to give birth? How far in advance?
Well, they usually schedule with us like 8 months ahead, a lot of them, 7 or 8 months ahead. But as far as when they're coming in, you can't decide on that until they're starting to have signs, labor signs.
Until they would begin labor. Correct.
Yes.
All right, so when they find out they're pregnant, they'll make contact with you to get in connection with your agency or ministry, we'll call it.
Actually, they don't contact me unless they're my patient. They contact the midwife, and the midwife lets them know.
All right, and then as you get closer to the date of birth, that's when they would come in.
Yes.
Sometimes you might not know till that day when they show up. Is that true?
Yes.
All right.
Did anything change other than the name, your DBA name? And I'm talking Did anything change in the operation that you had there as far as the pregnant women coming to give birth? Did anything change after you changed the name to Mama's Ministry?
Yes, we have a donation, and also they signed an agreement to be a part of the ministry.
Prior to the name change, you were actually charging, not a donation, but an actual charge. Is that correct?
Yes,
So and after you changed the name, then you started accepting donations, if I'm understanding. I didn't catch that.
yes.
Do most women that use your property to give birth make a donation?
Most average.
What, is there an average amount that they donate?
Probably on the average 400.
For their stay there?
Yes.
I'm going to take a few moments here, Your Honor, and see if I can locate the date of the show cause hearing in front of Judge Stutzman. Let's see if I got it. I got it. All right. In this case, Mrs. Yoder, we had a show cause hearing scheduled for July 2nd of this year at 9 a.m. And it was scheduled in the courtroom above us here in the same courthouse. Do you agree with that?
So July 2nd.
Yes. The court had ordered you to appear to show cause why you should not be held in contempt.
Trying to think, because there was one of them that we made a mistake by not reading everything and found that after the court hearing, there wasn't even anything in my name. It was under, there was two forms we received. One was for Alfred F. Yoder and one was for Alfred E. Yoder, nothing for me.
Are you saying you weren't aware of the hearing?
I was aware of it afterward, but we did file special appearance forms. We had all of our information on there. You received it, you know. And the judge too. There were special appearance forms here for you guys.
Are you saying you contacted the court and say, hey, I missed my show cause hearing, I need to reschedule? Is that what you're saying?
You have the information.
That's not my question. After you realized you missed the July 2nd, 2025 hearing, did you contact the court to let them know you missed it and you'd like to reschedule?
I turned in information here to give answers to questions because I cannot. I'm confused on which date's which.
Are you aware in the default judgment that entered against you and your husband that you were to pay some court costs to Colon Township? Were you aware of that?
Your Honor, can I answer that one for him?
Well, we'll see whether she can answer it, and then perhaps we'll get the answer from you if we need it.
I know I did see something with that, but being as it was all, there was so many confused things and so many things illegally written and illegally done. And plus it being under Mama's House birth center and not even having something like that existing, it being a ministry, I feel is all in default.
So it would be accurate to say you understood the court ordered you to pay some costs, you just decided not to pay them. Is that correct?
We paid something, I'm not sure, was it that or what it
You
was?
each paid $1,000 cash bond, which is still being held. And I don't believe anything was paid other than that.
I guess otherwise I'm not aware of something else that wasn't.
You have no recollection of paying either my office or going to Colin Township to pay costs in the amount of $265.48. Is that accurate?
I guess I didn't realize that that's not what the $1,000 is about.
Well, it's not what the $1,000 was about. The $265.48 were taxable costs ordered in the default judgment for you and your husband to pay. That's all I have for Mrs. Yoder, Your Honor.
All right, Mr. Yoder, thank you. You've done fine. It's not fun, as I said, being here. Just a minute before you get up and go. Is there anything else you wanted to tell me?
I guess most of what I wanted to tell was, wanted to say, I'm kind of blank on it, but I know we turned in forms to give our speech. Made so that Lance has one and we have one.
All right, thank you. You can step down. This would be a good time to take a recess for everybody. We'll take about 10 minutes and we'll be back. Yeah, up to you. Stop the record. I will also stop. All right, we're back. Let's go back on the record. I couldn't find any cookies. I had radishes. That's just not as satisfying as a cookie. But, I think I'll be good till lunch. All right, so we're continuing with the township's case in chief in this matter. Joanne Yoder has completed her testimony. Mr. Thornton, what's next?
I would call Alfred E. Yoder as my next witness, Your Honor.
Mr. Yoder, would you come forward, please? Good morning, sir. Are you Alfred E. Yoder?
Yes, sir.
All right, I'm going to do the same thing that I asked your wife. I know that you don't wish to swear, but will you affirm that any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I affirm.
All right. Thank you. Mr. Thornton?
Mr. Yoder, could you state your full name for the record, please?
Alfred E. Yoder.
And is it accurate that you also reside at 30158 Marsh Road, Colon, Michigan?
Yes, sir.
And that particular common address, 5-digit address, is to your home, is that correct?
Yes, sir.
And do you agree that 30100 Marsh Road, Colon, Michigan is the common address for the other structure on that property that was built as a home?
Yes, sir.
So those two homes and two addresses relate to the same property, is that correct?
Correct.
They're not separate individual parcels, correct?
Correct.
And I'm assuming you're aware, and let me start with this. I really want to concentrate on everything from March 13, 2025 forward, that being the date that the court entered the default judgment and permanent injunction. You understand that, correct?
Yeah, I know what you were trying to do, but like she said, there's no Mama's House Birthing Center in existence on that date. And that's who you were filing against.
So would it be accurate to say, because you reside there on a daily basis, correct?
Correct.
So you're aware that after March 13, 2025, your property there continued to be used by pregnant women to temporarily reside there and give birth, correct?
Correct. That is Mama's House Ministry running on a private contract.
But you're aware that it continued to be used under whatever name it was given at that time.
Correct.
Did you take any action to stop that type of activity?
No, because private, if you're running a ministry under a private contract, it's illegal.
So under that explanation, you would continue to allow that property going forward to be used as a,
There has been no births at that residence since I last talked with Milton.
and that being towards the end of August
Correct.
of this year. You intend to resume births on that property?
Very good possibility, depending on what the outcome is.
Were you aware that you were to be in court for a show cause hearing on July 2nd of 2025?
I filed special appearance papers that you and the judge ignored.
So the answer to that
And
is,
called sovereign gibberish.
okay. So the answer is yes, you were
Yes, sir.
aware that you were to be there.
I did appear with my paperwork on a special appearance, and you totally ignored it.
Okay. Were you there in person before Judge Stutzman on July 2nd,
Negative.
2025? Did you say negative?
Right,
Meaning no, you weren't?
right.
And were you aware that the default judgment and permanent injunction ordered you to pay Colon Township $265.48 in taxable costs?
No, because you were charging a business that doesn't even exist.
So would it be more accurate to say you were aware of it? You just didn't disagree. You disagreed that you owed it because of the way it was ordered?
The way I understood it, that is for Mama's House Birthing Center, and there's no Mama's House Birthing Center in existence anymore.
So you're not contending in any way, shape, or form that you actually paid Colon Township $265.48?
I did not pay them, no.
Do you have a role in the second structure on that property being used for pregnant women to come there and have births? I mean, do you regularly?
Honestly. Not started seriously.
I'm
Well, I
asking,
mean, are you the park their cars, or do you clean the rooms, or do you mow the grass, or anything that helps the operation of the center?
The only time I appear there is if something breaks down and needs to be repaired.
And you
Otherwise,
don't.
no.
okay. So it's primarily your wife that operates it, correct?
She takes care of the building, correct?
Okay. She's also a midwife, correct?
Correct.
So she also helps take care of the pregnant women that come there to give birth. Correct. That's all I have for Mr. Yoder, Your Honor.
Mr. Yoder, I'll give you the same opportunity as long as you're there. Is there anything else you'd like to say to me? All right, thank you, sir. You may step down.
My next witness, Your Honor, would be Rhonda Schwartz. Miller. Sorry.
Good morning. Do you swear or affirm any testimony you're about to give here will be true to the best of your knowledge and belief? All right. Also affirm, will you take a seat and state your name for the record, please?
Rhonda Miller,
How do you spell Rhonda?
RHONDA.
Thank you. Mr. Thornton?
Where are you employed?
County, St. Joseph County Courthouse, Clerk's Office,
Okay. What's your title?
Deputy Clerk.
Without going into all the duties of the county clerk's office, is one of the duties of the clerk's office to keep track of new childbirths
It is,
within St. Joseph County?
yes.
Do you have a role in that?
I do a lot of the home births.
Okay. Meaning you keep the records for the home births?
A lot of the home births we enter in by hand in the computer.
Okay. But you're the one within the county clerk's office that takes the information on home births?
I enjoy doing them, so I always volunteer for them. They're a little bit more work, but any of us can do it. But I like to do it, so I do it.
So you're the one within the office that primarily does it?
Yes.
Can you describe that process for us? Kind of when there's a new birth and you get the information on that, what happens?
Yeah, so if there is a home birth, there's some paperwork that we have to fill out to provide to the state. So it's usually like the midwife who fills it out, and they need to sign it to verify it. And then also like the attendant, like if there was a father on hand, he would also sign it, and it gives the weight, or gives the weight and the date that the child was born, their background a little bit. It's just kind of very information about the parents and about the child and where they were born.
Which is essentially on every birth certificate.
And what do you receive then from whoever was present at the birth that provides you the information? Is there a particular document you receive?
Yep, there's we have a form from the state that they provide, and that we give it to anybody. If they had a home birth, it has to be filled out. It's like a facility worksheet, and they just have to fill in the questions for us to provide for the state.
If I may approach you on.
Yes.
I put two documents in front of you. Can you describe each one?
Yep, the first one is the live birth certificate worksheet. It says a local registered state use only. So this is what like a midwife would fill out. Or if the mom or whoever has a home birth, they need to fill this part out. So this goes to the state. This information is always go to the state, and we give the state a copy also.
Okay.
And the second one is a facility worksheet for the live birth. This has things like where was the child born? It's just, and the father can fill this out, or also the midwife or whoever attended, who was at the birth, a neighbor, whoever was there attended. And they just have to verify that and fill out some information if they know the answers to this. Some of it's medical questions, so we also provide that for the state.
For each birth, do you receive both of those forms?
Yes. Mhm.
Your Honor, I'd ask that these be marked the plaintiff's exhibits 1 and 2 with the live birth worksheet being number 1 and the facility worksheet for live birth being number 2. So that's the first.
All right, Mr. and Mrs. Yoder, these are simply the forms that the clerk has described that you use. Do you have any objection to those being admitted as an exhibit? Mr. Yoder expressed no, and that's number 2. No, wait a minute. I get it backwards. That's number 1. That's the live birth worksheet. And this facility worksheet is number 2. They are admitted.
So it's those 2 forms that your office takes in, the county clerk's office, correct?
That is correct.
And then what happens then? Once you receive those forms, what do you do?
So then we go onto our state website and then we enter the information into them. And we also scan the forms into the state website so they have the actual form themselves. So then from there, we can generate a birth certificate if we have all the information on the worksheets.
And the birth certificates are essentially private documents, correct?
Yes, very private.
You do not hand those out to the public.
That is correct.
They have a lot of private information in them.
Yes.
As part of preparation for today, I asked you to prepare a report. Is that correct?
Yes.
And more specifically, I asked you to prepare a report of how many birth records you had from Mama's House Birth Center and or Mama's House Ministry. Is that accurate?
Yes.
And the time period I gave you was from March 13 of 2025 through the most current you had. Is that correct?
Yes.
And did you prepare such a report?
Yes.
And for the record, I'm going to hand the Yoders a copy of what I'm going to be handing Ms. Miller. Is that the report you prepared pursuant to my request?
Yes, we had, yes.
And essentially, it'd be more accurate to say I sent your office a subpoena for the records, correct?
Yes.
Can you explain? I'm going to provide this so that the court can follow along a copy.
Thank you.
Can you explain what these are and I guess where you're starting? Because I've handed you a 2-page document and a 1-page document. Could you explain this report and how you produced it?
So the first one is the daily birth log that has the 2 pages to it. This is, we have to go onto the state website and run a report. We can run it from the date that you had suggested. It was 3/13 to 9/23 yesterday. And we have to put in like a range. It'll pull up from the address. I believe we ran it because at we had Mama's House and then we had Mama's House Ministry. So we had to run it with to get all the births of that era, that time, we had to run it by the address, I believe.
So hence the 2 pages. The first page, would it be accurate to say, is it contains the address 30100 Marsh Road.
Yes,
And the second page contains an address of R002. I believe that has to do with the rural route.
it was like R001 and then Marsh Road and then something after the address like that. So when they put it on, that was different how they worded it on the worksheet when it was up.
But the births on this report, you have no question, are all originating from the Yoder's property on
Yes,
Marsh Road.
that's
Is that correct? And essentially the 30100 Marsh Road. That home with that address.
That is correct.
So what does this report tell us? How many births were there between March 13 of 2025 and today's date?
Yep, a total of 79. There was 75 in the first one and 4 on the next page.
Okay. And what is the third or the single page births per week it's titled?
Yep, so this one just gives, from that date also, we listed how many births there was per week that we received. And this one has 8 pending. And so this one has 87 total because there was 8 that we had to return back that we were missing some information on. So we turned those back. So that would have been, we didn't get those to the state. So that way that says 87 instead of the 79.
So you're waiting for more up-to-date or more complete information before those get sent on to the state?
Yes.
Okay. So the births per week indicate how many births occurred at 30100 Marsh Road, Colon, Michigan, from March 13 on through today's date, correct?
Correct.
As reported on the forms that were admitted as exhibits 1 and 2.
Yes.
I'd move for admission of those as one exhibit, Your Honor, plaintiff's exhibit 3.
Mr. or Mrs. Yoder, do you have any objection to the admission of the clerk's report regarding the births? I would note there's no births reported after September 1. Oh, wait a minute. I guess possibly up to September 6th. The rest of September is 0 births. Hearing no objection, I'm gonna have you mark this as exhibit number 3.
I mean, the court has admitted it.
Yes. Thank you. Admitted.
Have you also, since March 13 of 2025, have you had any conversations directly with Joanne Yoder regarding the births that are occurring on her property?
I do. If I have a question, if something's not filled out correct on the worksheet, I call her. It's just short conversation. She'll answer the question and yeah. So probably about 3
Okay.
within that time.
And does Joanne Yoder sign some of those worksheets that you get?
Yes.
Does she sign most of them?
Yes, whoever fills that out, they're the midwife of that. The reason they sign it, if they're unlicensed, they sign that. And so if she was there at that birth, then she would be the one signing that.
So it's accurate to say that each one of these 79 births represented on Exhibit 3, your office received filled out worksheets for all of those births.
There's some in there that was performed at the birthing center, but they're licensed midwives, so they do it through the computer. So we don't get, just a few of them are licensed midwives. They can already put it into the state. So we wouldn't get births on those if they're licensed midwives.
Okay, so those were, the information was given to you electronically, not on a paper.
Correct, electronically.
That's all I have, Your Honor, for Ms. Miller.
Is there a delay? For example, if we just pick a week, June 29th to July 5th, 3 births. Does that mean the children were born between those dates, or that's when the reports were filed?
No, that would be, I think this is the actual birth date.
All right,
The report runs by the birth date.
okay. There were 2 births between August 31st and July or September 6th, and then none thereafter. Is that what the report shows?
Yes.
All right, thank you. Exhibit 3 is admitted. Do you either of you have any questions for Ms. Miller?
Negative.
All right, thank you. You may step down.
The next witness, Your Honor, I would call would be Joseph Klein.
Good morning, sir. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please have a seat, state your name and spell your first and last name.
First name is Forrest, EST. Last name Klein, Kline. Most people in the court know me as Joe Klein. Middle name is Joseph.
Thank you.
Can you state your, do you have a position with Colon Township?
I do. I'm their zoning administrator.
And who's your direct employer?
Safe Bill.
Is it Safe Build Incorporated?
Yes.
It's a building code and municipal services company.
Correct. Full service building company. Yes.
And Safe Build has a contract with Colon Township.
Correct.
To provide building code services and zoning administrator services and ordinance enforcement services. Is that correct?
That is correct.
How long have you been the zoning administrator?
6 years in June, I think it was.
Are you familiar with the Alfred and Joanne Yoder's properties on Marsh Road?
I am, yes.
Would that include 30158 Marsh Road and 30100 Marsh Road?
Correct, yes.
Have you been to those properties?
I have, yes.
Have you handled zoning permit requests for those properties?
I have, yes.
As part of your position as zoning administrator, have you been inside the structure home that has the common address of 30100 Marsh Road?
I have, yes, on one occasion.
Approximately when was that?
It was a few months ago.
And is it accurate to say that the Yoders allowed us to come and take a look at what was happening there at that address?
Yes, they did. They allowed us to come in the residence and spoke to us In the residence, yes.
As in preparation for today's hearing, I asked you to run what we commonly refer to as the fetch documents for the Yoder's properties. Is that correct?
That is correct.
Did you do that?
I did.
Approach, Your Honor.
Yes.
Are those, actually, I'm going to let you do it. How did you, are those the documents you produced pursuant to my request?
Those are, yes, I got in the St. Joe County Fetch's website, which is reflects records with parcel IDs and owner information, along with various other property information. And yes, I got on that website. I printed these off this morning for work.
And how many reports are there?
There are 2 here.
And which parcels by parcel number are you, and when you give the parcel number, also give the common address that goes with that.
Okay. So parcel number 002-021-006-05, also known as 30158 Marsh Road. And I believe it's also 30100 Marsh Road as well.
That's the one, you've been here this morning, you've heard the testimony. That's the parcel with the 2 homes on it, essentially.
Correct, yes.
One being Mr. and Mrs. Yoder's residence, their home, and the other being the 30100 Marsh Road that's used as the birthing center.
Correct. My understanding is the birthing center is the west structure and their actual home is the east structure on that parcel.
There are other outbuildings on the parcel, but these are the 2 homes on that parcel.
Correct.
I do not have extra copies of those, Your Honor.
That's fine.
I thought it would be, so I can show them to the Yoders, but I would move for admissions of those as exhibits 4 and 5.
They're just public records in the county.
Correct.
Geographical system of all parcels. This is essentially an aerial picture of your house. Do you have any objection to that?
Negative.
I would ask that the O file be exhibit 4 and the 10 exhibit 5. And I'm referring to the last 2 digits of the parcel.
Yes.
So 5.
That's exhibit 4.
Just for clarification purposes, and I can give you the exhibits back if you need them, the parcel number ending in 10, which one is that? That's not 30158 or 30100, correct?
Let me see if I have that.
Well, let me just give you the marked exhibit back.
I would like to confirm that.
Yeah, this is the one I'm talking about that ends in 2 digits.
That is correct. That is not correct.
So what is that of?
That is of a new parcel that was divided off the main parcel. Would have to look at the dates to see now it's done. It was sometime in the last, I think, 2 years or so. So that's its own separate parcel for a new structure.
So in short, that is the parcel, just for reference, that is the subject of the other case that
Correct.
Colin Township has with the Yoders. That's case number 25-533-CZ.
That is correct. That is for that, yes.
All right, exhibits 4 and 5 are admitted. One describes the house of the Yoders and the building that houses the birthing center. One is a house just down the road, which houses a new structure that was under construction. Yes, Ms. Just a minute. Ms. Yoder, you have a question?
So the question Lance had for Joe about entering the 30100, that was against our will, very illegally done. But Attorney David Marvin was working with us. We had him helping us. And he knew that we wanted to work in peace. And so he said that he feels that if we let Lance come in and see for himself that this is all legal and everything is well taken care of, that we can work in peace. So that's the only reason we agreed, because we wanted to work in peace.
All right, this was,
We are still being harassed.
so this was in 2025,
Yes.
Negative.
2024.
No, this was before.
That would have been like December of 23.
All right, so at that time, David Marvin was the county prosecuting attorney.
It was right just before he moved up north.
I can confirm that I did have discussions with David Marvin about this matter. His official, he was communicating with me and corresponding with me. He officially said he wasn't formally representing the Yoders, but he was talking to them. Well, I would also state that any implication that Mr. Klein or myself, and I was there too, entered without permission or against their will is just inaccurate. We would have never entered.
Well, it may be a matter of perception, but obviously you weren't illegal entry. But Mr. Marvin was the county prosecuting attorney at the time this took place. He was county prosecuting attorney until December 31.
I would have to go back and look at that correspondence dates and those things. I don't believe so. I think he had finished by the time he started corresponding with me. And
So it would have been sometime after January 1.
to the best of my recollection, because I know he told me he was planning on moving up north at the time, and he was getting ready to move up north.
Well, he didn't come to work for the last couple of months. He wasn't here maybe in November or December.
Could have been during that period of time. I would have to check.
Ms. Yoder, you've got some input on this?
July, I was in January
Was it January? Or that been after his term ended?
last year.
Oh, January of 2024?
I think so.
Probably. This has been going on for a long time already.
All right, well, all right. I guess it isn't crucial. I was just surprised that he would be, I didn't know if he was doing this in his role as county prosecutor or as advisory counsel, and whether he was still prosecutor or not. I guess it doesn't matter. But the point is, maybe you weren't real pleased about it, but under the advice of Mr. Marvin, you let them come in and inspect the premises.
Your
So,
Honor, sir,
yes,
like she said, we tried to work in peace, work
Okay.
with a little bit of common sense with these guys. And you can see how far we've got.
We did hire David Marvin for an attorney.
all right.
But he moved out now.
Yes, he moved to Mason County, but I don't think he's there anymore. I'm not sure where he is now, but he's not here in our county. All right. So you paid him money to represent you? All right, let's proceed.
Mr. Klein, when is the last time you were out at the Marsh Road Properties?
On the actual property itself,
No, just, or even driving by.
say it would be, it's probably been a few months since I've actually been by the property itself.
Okay.
I did ask an associate to go by there recently and verify some things for me from the road, but I have not been out there myself in a few months probably.
Okay. And is part of preparation for today, did you locate anything on social media to do with Mama's house?
I did look and see what was still floating around out there, and there is a main internet page that still says Mama's Birthing Center on it. When you open the link, it does take you to the, I believe it's Mama's Ministry, Mama's Birthing and Mama's Ministry or something along that line for a title.
Yes.
That has nothing to do with us doing something. Like whoever's doing that, if someone's looking on social media, there's a lot of false things out there.
All right, so
As far as that, I don't even own a computer.
All right, so you don't run a
So
website
I
for your.
run nothing. I don't do no advertising whatsoever.
All right, thank you.
So whoever has that posted, I have no idea. It's not got anything to do with me.
Mr. Klein, did you run a screenshot of what you found and where did you find it?
It was a local internet search, a Google search, and yeah, this was at 8:04 a.m. this morning that I located that. And then when I opened the link, it says Birth Ministries, Mama's House of Ministries, and then it just goes on with more literature and pictures of the inside of the building and whatnot.
I would move for admission to this as Exhibit 6. Just based it just solely on the, it's out there on social media.
All right, well, for what it's worth, I take Mrs. Yoder's under oath. She doesn't run this website. Doesn't even really know about it, but apparently it is on there. If somebody was to do a Google search, this is what they would find. So for that purpose, I'll allow it, and it's admitted as exhibit number 6.
Your Honor,
Yes?
is there a possible way we can find out who would have posted something like that?
Maybe somebody can. I'm not computer literate enough to do it. Facebook is a
Deceiving thing.
I'm not on it, but it's a thing unto itself. For example, there is apparently a Judge Middleton Facebook page. I've never been to it. Somebody operates it, but I'm not really sure who it is. I don't look at it because I don't know. I don't want to know what people are saying about me.
I guess I can't see how that can be held against us.
Well, I'm not holding it against you. I'm just saying this is what would be found. For example, if somebody posts something on my Facebook page, I'm not responsible for it. Someone posted a picture. I didn't see it. My wife did, and Joan were happy about it. A picture of me standing with another lady on the beach. I was wearing a winter coat. I had a picture taken with someone when I was walking down the street here in Centerville, and she photoshopped me and her on the beach in Florida or something, but I was never there with her. If I was in the beach in Florida, hopefully I wouldn't be wearing a winter coat. But anyway, yes, I'm not holding this against you. I'm simply noting that it exists. As far as I know, the people that go to my site are very kind. I don't go there myself.
That's all the questions I have for this witness, Your Honor.
All right. I have a couple. I'm late to the game here. There were a lot of things that were decided before I got here. And my first knowledge of this was when I saw a number of people at a county commission meeting the night we did our annual report, and they were expressing their support for Mama's House at the commissioners meeting, just in the public comment section. Before that, I didn't hear anything about it. Then I inherited it later. My understanding is the gist of this is not an action by the state Department of Public Health, any issue of licensing. The state of Michigan or the Attorney General has no involvement in this case. This is simply Colon Township's enforcement action. Is that correct?
That is accurate.
All right, and I don't know whether there ever was any, that's a question I've always had. Is there any sort of state licensing oversight here? But that isn't it. So the primary issue, or the couple, is one of the issues, Mr. Klein, that there are two houses on the same piece of property?
No, that is allowed in Colon Township under certain circumstances. I believe these meet that criteria. The problem is the zoning for the agricultural district doesn't allow for the.
All right, that was my next question. In many townships, you can't put two houses on the same piece of property. You can't share a well, you can't share a septic system. Each one needs their own. So that's not one of the violations.
Yeah, that is correct.
The crux of this is that portion of Colon Township is zoned agricultural, and this is not an agricultural use, so it's outside the zoned designation for this property.
Correct.
Which is what the whole thing rests on?
Primarily, it's the use. Yes, the use is just not allowed in that district. So,
Your Honor,
Yes, sir.
I'd like to have that somewhat explained, because Colon Township said you can't do it. No, I should say Lance Thornton said you can't do it. But if you go on the Colon Township map, and if you look for commercial businesses in the agricultural district, there's like 4 of them within 2 miles of them, and that's like 2 acres.
Okay, that may be true. That ship has sailed. Judge Stutzman made a ruling on this that said you can't do it anymore as of March 13th. That's where I've come into the game. I'm the zoning guy. You were at the hearing. At some point, the township didn't want me to handle this, and they asked me to be removed, and I denied it. I do zoning hearings in every village and township in the county. Each township or village may do things differently. And I see routinely where I am doing a zoning enforcement case, but I know that 2 miles down the road is a property that's even worse. And I'm not dealing with that property. I'm dealing with the one that's in front of me. So I don't know whether there are other non-conforming uses out in the township that aren't before me. All I know is this one was brought to Judge Stutzman. The township argued that this enterprise does not fit within the zoning description for this parcel, and they're asking to enjoin it. And he did. He said, you can't do it anymore. And then they contend that you continued to do it after he said, don't do it anymore. That's what we're here now. I've said more than once, you could have benefited and you could benefit from legal counsel. Mr. Marvin was apparently in the picture for a bit. So once the default entered, you would have had an opportunity to move to set the default aside or ask for a rehearing. Those things weren't done. That was in March. So that order stands. Judge Stutzman in a circuit court order says you can't do it. And you can't do it apparently because the township does not allow this sort of enterprise in that agricultural district. It isn't done, at least under these purposes, because they allege that it's unsanitary or it's not properly set up with well and septic or removal of medical waste or any of those issues. It's simply, if your neighbor came and wanted to set a birthing center up across the street, the township would say you can't put a birthing center in that location. Apparently this has been here for a long time. There may have been some argument that it was grandfathered or preceded the zoning. I don't know about that. All I know is the order is in effect and it's not been set aside, and Judge Stutzman said you can't do it. And that's where we start. So you may have had defenses, but they weren't presented. And apparently they aren't saying you can't do this, you just can't do it there. I was surprised that there is not some sort of state licensing requirement, that if I wanted to start Jeff Middleton's birthing center in Park Township, I could put up a building and do it. I had naively assumed that there needed to be some sort of state licensing to do this. But babies have been born long before there was ever any township ordinance or before there were even hospitals. So some of your views on this, I understand where you're coming from, but they weren't ever properly raised and they weren't ever moved to set aside the order. So the order's in effect and you have a right to appeal that to the Court of Appeals. But I think the time limit for that is probably passed. So you'd have to ask for leave. So you can't do this because Colon Township says you can't do this in an agricultural district. And Judge Stutzman agreed and entered an order that said you can't. Now, one of the things you cited in the Michigan Constitution is the governmental interest. And is there a compelling governmental interest to not put a birthing center in the middle of an agricultural district? And arguably the answer to that is yes. This property is about as much in the middle of nowhere as you can get to in St. Joseph County. It's not easily accessible to ambulance or fire service. It's got dirt roads. It's in the middle of corn country. St. Joe County is about 74% agricultural. About 74% of the land is farmland. And you're right in the middle of it. About 5% of it is surface water. So the roads and the rest of us live in the other 20%. I guess they're arguing this should be, if anywhere, in the other 20%. So anyway, I'm here to enforce Judge Stutzman's order of March 13th. And it's in effect whether you like it or I like it. That's the order. Mr. Thornton.
I have no other additional questions for.
Excuse me, I vented there. Mr. Or Mrs. Yoder, do you have any questions for Mr. Klein?
Yeah, he's sitting there as a witness. And from my understanding, from the FOIAs that have been filled out, he doesn't even have a valid oath of office. And if you look in the Attorney General letter, It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue and serve occurrence tickets upon persons who violate the building code or zoning ordinance of a city. It is my further opinion that city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or further position. That was from the Attorney General.
That's an interesting piece of information. Again, that ship has sailed.
He's sitting there.
Oh, well, he certainly can testify. Some villages and townships actually appoint their zoning administrators. And I think what they probably did is appoint his company as the zoning administrator. But again, that ship sailed a long time
If
ago.
he's not carrying an oath of office, he's got no right to.
Well, you may have had a right to raise that objection some time ago, but the order's already entered. And you haven't moved to set it aside, and there's been no move to set aside the default. That hasn't been appealed. So that issue isn't before me. He issued you some citations. Now, very late in the game, you're raising this, which is one of the reasons why I've always believed you could have benefited from legitimate licensed legal counsel. Mr. Klein, you can step down. Thank you. Thank you.
My next and last witness for this matter is Teresa Owsley.
All right, just a minute. Are you guys good? Can we go on till noon? Do you need a recess?
Your Honor, I respectfully note our objection for the record and reserve all rights to appeal.
All right, I respect that. You've made your objection. It's noted for the record, and you reserve your right to appeal. Mrs. Yoder, do you need a recess? All right, then we'll continue. Thank you. Good morning. Please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief? I affirm. All right, thank you. Would you state your name for the record, please?
Teresa Owsley.
How do you spell Teresa?
Teresa.
And Owsley?
Owsley.
Thank you. Please have a seat.
This should be brief, Ms. Owsley. What's your, you have a position with Colon Township, correct?
I do, yes.
What is that position?
I am the township treasurer.
So as township treasurer, you keep track of what comes in and goes out as far as financial transactions for Colon Township. Is that correct? That's part of your duties. As part of preparation for today, I ask you to take a look at the township records. Is that correct?
Yes, it is.
Essentially from March 13, 2025 forward. Is that accurate?
Yes.
And I ask you to check those records to see if the Yoders had paid, or anybody had paid on the Yoder's behalf, the $265.48 in taxable costs ordered as part of the default judgment, correct?
Correct.
Did you do that? Did you take a look at all the records?
I did, and I even searched by name, and there were no records saying that they had paid.
So as treasurer of Colon Township, you have no record that the Yoders nor anyone on their behalf have paid the $265.48 in taxable costs ordered in the judgment.
Right.
That's all I had.
All right, thank you. And I think the Yoders confirm that. All right, thank you. You may step down.
That's all I have, Your Honor, for witnesses.
Your Honor,
Yes, sir.
if I'm not mistaken, that was another witness without a valid oath of office.
I don't know whether she has one or not. I think most
From the
township,
FOIAs that were pulled, no.
well, she testified to something that you agree with. You didn't pay it.
But she was used as a witness.
Well, you don't need to have an oath of office to be sworn as a witness. If you're standing on a street corner and you watch an accident occur, they can subpoena you to tell what you saw. Any layperson is entitled to testify to items within their knowledge. So I'll know you can claim she doesn't have an oath of office. I do, by the way, and have had one for 46 years. But all right, I'll note your objection on that as well. All right, no further testimony from the township?
That's correct, Your Honor.
All right, Mr. and Mrs. Yoder, the township has rested their case. You have an opportunity to tell me anything you want me to know. You don't have to. After we do this, we're going to take about a 10-minute break, and then he's going to argue. He's going to tell me what he wants me to do, and then you can respond to that in the argument. Is there any other evidence you want me to have here this morning?
Negative, Your Honor.
All right, let's take a short recess. We'll come back at 11:15. The township will tell me what they're asking for, and then you can respond to that. All right, I'm gonna stop the live. Being here, this is a public procedure. Alfred Yoder and Joanne's Yoder's name, so is Miss Township versus Alfred and Joanne Yoder. File number is 25040CZ. Testimony portion of this hearing has been completed. Court's heard testimony under oath. We've received 6 exhibits. And I'm going to give each of the parties an opportunity now to argue what they think should happen. Mr. Thornton.
Yes, Your Honor, and my comments will be relatively brief. The Yoders made a decision to not participate essentially in this case when they should have participated in it and had the opportunity to participate in it and be heard. They then, after the court's default judgment and permanent injunction entered, and it's very clear that they were aware of that default judgment and permanent injunction. It was served upon them. They knew what it said. They then, because they disagreed with the decision, they intentionally kept violating the order. It is very obvious from March 13th through now and from the exhibit entered on the number of births out there that the births could have stopped much sooner than they did. And I'm not sure from the testimony given by the Yoders that they intend to permanently stop them at this point, but I guess we'll see on that. My point is that the Yoders contempt, and I think they are in contempt of Judge Stutzman's and this court's order, was intentional. And only from the township's persistence in getting to this hearing are we here today in almost the end of September. So the township is going to request a fine under MCL 600.1701. Actually 600.1715 of $3,500 per defendant to get the point across that the circuit court's orders are that and need to be followed or legally contested.
And pay the original $243. Now I have $2,000 of bond money, which I can allocate toward fines and costs.
Yes, we still want the $48 or
Yes.
whatever it was. My understanding, the township gets none of that $7,000. So I would request, and the statute does provide for restitution to the township. I'm not prepared today to submit a detailed accounting of how much extra cost the township was imposed. I understand the township's not going to get its attorney's fees for the entire case, but it seems unfair to the township, to the missed hearings, the appearances I appeared for, the motion and order to show cause proceedings, the impromptu unscheduled hearing when the Yoders unexpectedly showed up at the courthouse, and then today's proceeding. I would like to request to the time to submit a request for the court's consideration to award restitution directly to the township for some of those extra fees and costs that they incurred.
That's generally called a bill of costs. As you know, I often, in fact, usually give any fine money to the township as restitution rather than keep it to the county. Zoning enforcement's expensive. If a policeman charges someone with a crime, with drunk driving, the county pays for the prosecutor, the county pays for the judge. It doesn't work that way for the townships. If the township proceeds to enforce an ordinance, the township pays for it. And if there's a lawsuit, there was a lawsuit in my township that cost the township about $25,000 in attorney fees, and they lost. So my practice is often to just give any court fine money that would go to the court to the township to offset the cost of the case. All right, so you're asking for $3,500 per defendant. The maximum would be $7,500. And that I allocate that as restitution, but we need a bill of costs and a further restitution hearing. All right, thank you.
And the 248.
And the 248. And as I indicated, I've got $2,000 in escrow from their cash bonds that they posted. All right, Mr. and Mrs. Yoder, their contention is that you violated Judge Stutzman's order by continuing to have births at your center. Now let's repeat. You changed the name of the enterprise from Mama's Birthing Center to Mama's Ministry. And it is a ministry. I guess I won't deny that. It's part of an overall worldview of things. But the ministry or Mama's Birthing Center wasn't charged. You were. It's in Alfred Yoder and Joanne's Yoder's name. So as Mr. Thornton argued, that name change is irrelevant, but it isn't really that easy. People do that. They're sued on a debt. They owe somebody money, and they change the name of the company and say, well, I don't owe the money anymore. That company doesn't exist. Maybe that might work sometimes if there's a corporation or something. The other thing people will do is they'll transfer the property to somebody else for $1. Somebody's got a horrific toxic waste site, and the township pursues enforcement, and they transfer it to their granddaughter for $1 or something, and argue we don't own that property anymore. Sometimes we have to parse that out. At any rate, this action is against the two of you. Judge Stutzman ordered back in March that you not have any more births at that center in terms of a permanent injunction. Doesn't matter what the name of it is, you can't do this at that place. And you had births through April, May, June, July, September, and I'll take it at your word that there weren't any births after August 29th. and none in September. Obviously, your place is, well, if we've had 87 births in 5 months, you're busier than some of the hospitals. I suspect there weren't 87 births at Sturgis or Three Rivers Hospital during that period of time. At any rate, they did present sufficient evidence that you've continued to have births there in violation of that order of March 13th. So I find that you are in contempt. They're asking for $3,500 to make the point. I think the point is going to be made with the cost to the township of doing this. So we will set a hearing regarding the sanction after you submit a bill of costs. My inclination is to reimburse the township for their costs. That may be enough of a sting. And as I said, I do have $2,000 that I can apply to the fine and the contempt. I do fine beyond the required standard. Township has established that you are in contempt for continuing to hold births through the summer at this facility. Now, let's talk about what happens next. He ordered that you can't do this there permanently. You don't agree with that and have not agreed with it, and you have a right to disagree with it. What you don't have the right to do is to continue to do it. If you continue to do it, they're going to file a petition for criminal contempt, in which case I can put you in jail for violation of the order. I could order under the equitable authority under the zoning law that the facility be torn down. I don't want to do that, and I don't want to put you in jail. I want you to stop. What you need to do, you obviously have a constituency. People like your service. I heard a number of people get up at the county commission meeting and say that we need this, we want this, and why is the government messing around with this? So you got people that want your service. You need to do it somewhere where you're allowed to do it. There are places that you could cite this that would not be in a zoning violation. The township says you can't do it here. That wasn't up to me. They filed the action. There was a hearing. Judge Stutzman made a ruling. Again, you had an opportunity to participate in your defense, but you didn't. So now we're all stuck with the order. You can't do this here. This isn't an order, but my recommendation is find some place where you can do it. And your followers will find you. We're going to set a second hearing regarding the amount of the fine. And Mr. Thornton will provide a bill of costs. You'll have an opportunity to object to that. Then I'll make a ruling on how much the fine is. We can set that for Wednesday, October 15th at 1:30. Does that work for you?
It does, you know. You said 1:30?
Yes. Mr. Thorne, I'd like you to do an order stating that the court found that the plaintiff had met their burden of proof and the defendants were found in contempt. And the court intends to order a civil fine or restitution. And they will set a hearing on the amount of that fine for Wednesday, October 15th at 1:30. All right, we now have to deal with the other case. Yes, Ms. Yoder?
For the Judge Simpson hearing, I still feel that was very much, I mean, considering we had notified them, we had given them information about this is a private ministry, and being that would be totally out of their jurisdiction on doing anything like this against a private ministry before they made a court hearing. They had all this, and then Judge Simpson lied about it. He said that we attempted to file our paperwork and we did not. We did, it's all proven fact, it's stamped, it's dated. It was done February 6th.
Well, you can appeal these. His ruling has been made and you did not move to set the ruling aside or appeal it. So it stands. If you had some defenses that could have been raised, they weren't. Now, a higher court, higher than me, may have a different view of it. So it's difficult to appeal a case to the Court of Appeals. I've done it, and you'd be very, very difficult for you to do this without legal counsel. And they're probably going to uphold his ruling. So if you want to continue your ministry, my suggestion is you find a place to do it where it conforms with the zoning regulations. Then you can continue with your ministry. Your clientele can still utilize your services, and you'll be in compliance with the law. All right, we have the preliminary injunction. We're going to shift the record here to the next case, which is file 25533CZ. That was the default judgment that entered. Request for default was filed by the clerk. What's the date of this? It's filed August 23rd of 2025. And I did a preliminary injunction order in that case, which I'm pleased that the Yoders have attempted to comply with that since my order of August 29th. The order that Judge Stutzman entered had a reasonable time in it. That time is passed. So the date is September 1st. That date is passed, but there should be no further operation of Mama's House at this location after September 1st, 2025. So we're going to take out the reasonable time requirement. The people after that date have found other remedies. All right, let's shift to the new case, Mr. Thornton. That request for default was submitted. I haven't seen any response. What's your position regarding that?
Your Honor, I would like to call one witness, the township building official, to put on some brief testimony that would add a little bit to the admissions by the Yoders to the complaint, to each allegation in the complaint. And then I would request at that point, once that testimony is received, the entry of the proposed default judgment I submitted in this case.
Mr. Yoder, would you come forward again?
Actually, I don't.
I mean, Mr. Klein, I'm sorry.
Actually, it's Lance Bonifield.
Oh, all right. Mr. Bonifield, would you come forward? Good morning. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
And would you state your name?
Lance Bonifield.
Could you spell that for us?
LANCEBONIFIELD.
Mr. Thorne.
And you're employed by whom?
Safe built.
And again, Safe Belt has a contract with Colon Township, correct?
Yes.
To provide building code official services. Is that correct? Inspections. Okay. And are you the present person that does that in Colon Township for
Yes.
Safe Belt and Colon Township?
Yeah, I do plan reviews and building inspection.
And are you familiar with the Alfred and Joanne Yoder's property commonly known as 30246 Marsh Road, Colon, Michigan?
Yes.
And this has a fairly recently built, quite large structure on it, correct?
Yes.
Approximately a 6,400 square foot structure.
Yeah.
And as part of preparation for today's hearing, I asked you to review Safe Built's entire file on this property. Is that correct?
Yes.
Did you do that?
Yes.
It's already established by the pleadings, the verified complaint and the failure to answer those allegations have been admitted that 2 stop work orders entered on this property. Is that your understanding?
Yes.
The first one entered on February 2nd of 2024. Is that correct?
Yes.
And the second one entered on April 8th of 2025. Is that
Yes.
correct? No, you didn't post those stop work orders. Somebody else with Safe Built did. Is that accurate?
Yes.
But you know that information from reviewing the file.
Yes.
Have, in your review of the file, can you tell us whether either of those stop work orders were ever rescinded or terminated by Safe Built or Colon Township?
No, they haven't been.
So they are still in place.
Yes.
Having reviewed Safe Built's file on this matter, can you tell the court whether building inspections have been conducted on the structure located at 30246 Marsh Road?
The only inspection performed there was footing inspection.
Would there have been, should there have been other inspections performed?
Yes.
What is the kind of the status of that building?
Well, several inspections haven't been done, and I saw that when I went there. We should have had framing, insulation, whatever trade happening there, roofing and final. Those haven't been done.
Haven't been requested by the owners. So therefore the structure has not been inspected.
Yes.
What state is?
All right, let me start. That includes electrical, mechanical, plumbing inspections.
Correct.
If we went out there today, what would we see? What status is that building in? How far along is it?
Final. It would be complete. Or the last time I was there was to post some documents on the door, and there was some siding that wasn't done and some site work that wasn't done.
But you viewed the inside of the structure through windows, is my
Yeah.
understanding?
And it's drywalled and the flooring is in complete.
And there is no and has been no building permit on this building for quite some time, correct?
Correct.
The former contractor that pulled the building permit terminated the permit, correct?
Yes.
In your opinion, or do you have an opinion as to whether this structure as built and as viewed by you the last time you were out there, is it built as a home or is it built as something else?
It looks like a healthcare facility to me. I opened up the drawings and looked at the floor plan. It looks like patient care rooms.
Is there a kitchen?
No kitchen.
He's not in the drawings.
That's all I have, Your Honor. Again, that's in addition to all the verified allegations in the complaint that are considered admitted at this point.
Is there plumbing and bathrooms in the facility?
I'm not sure. I've never stepped into it.
Are they in the drawings?
I don't recall. All I looked at was the floor plan.
All right, thank you. Mr. and Mrs. Yoder, do you have any questions you wish to ask?
Yeah, I've got a little bit of a question on the affidavit for a search warrant. The affiant, or whatever they want to call it, is signed by Lance Bonifield. And from the FOIAs that were requested, he's got no valid oath of office. And if you go back to the Attorney General, he's got no right. It is my opinion, therefore, that the city building inspectors and zoning enforcement personnel are not authorized by law to issue or serve occurrence tickets upon persons who violate the building code or the zoning ordinance of a city. It is my further opinion that the city building inspectors and zoning enforcement personnel may not be empowered to do so by city ordinance or charter provision.
What's the name of that opinion?
That's an affidavit for a search warrant.
No, the Attorney General opinion you just quoted from.
Frank J. Kelly.
Yeah, but what's the name of the parties?
Delaware County v. City of Gladstone, 305 Michigan, 50.8 NW 2D 908, 1943.
All right, county of, what county
And
is that?
on that same,
What county is that?
PA.
Delaware County v. City of Gladstone.
Also known as Happy Rock.
On the same affidavit for search warrant, it's a prosecuting official, Lance Thornton. I thought he's an attorney. I think he's running two different deals on the same. And then if you go back to the search warrant,
And he doesn't have a legal oath of office either.
we've got the officer as Lance Bonifield. If he's got no oath of office, he's an officer. So I'd say that whole thing's null and void.
All right.
I've got motions here. I'd like to have for you and Lance to have one of these.
Yes, would you hand them to the bailiff? Yes.
If I could respond to what he said.
Well, you can ask him questions. We're not to the argument part yet, but if you have a question for him, you can ask it. Otherwise, I'll give you a chance to speak when we get there.
I'll just wait.
All right, this is, I'll get it date stamped by the clerk. I'll just put filed, bench filed. 9/24/25. I guess it's entitled Motion to
dismiss for lack of jurisdiction in violation of constitutional rights.
Okay.
Introduction, defendant.
No, you don't need to read it all. I've got it here. Again, there's a timing issue. They filed this lawsuit. You had 21 days to respond. It did not respond.
We filed special appearance papers.
That's not an answer to the complaint. And then the time to answer has passed. So, all right, yes.
So, as far as the responding date, so we did start getting things together to respond within 21 days. And then we were served more papers on this all being changed from Judge Stutzman down to you. And there was no response timing on that form. That's why we brought a response on the date of the hearing with our special appearance forms.
Mr. Thorne, what's your response?
The court rules provide that once the defendants are in default, which they are, defaults have been entered against both Mr. and Mrs. Yoder for failure to respond with an answer to the complaint recognized by the Michigan court rules, that they no longer can participate in the defense of the action until that default is set aside, and that default has not been set aside. It's so I would object to any consideration of this motion filed here today. Is one, it's not a motion to set aside the default, and it's not been filed timely and was not served upon me and the township in time to respond to it. We can't be expected to respond to something we're given during the hearing. This case has been pending quite a long time also. The whole jurisdiction issue and this oaths of office, they've cited some of these arguments before. The statute they're relying upon, which is MCL 85.10-16, is Fourth Class City Act.
Yeah, the case that they were quoting from is a city case, not a township case.
And I believe the court's aware that there are different statutes and acts in Michigan that govern cities and townships. And I will represent as an officer of the court that the Fourth Class City Act does not have anything to do with Colon Township. The Michigan Constitution, Article 11, Section 1, really requires any official that is a legislative, executive, or judicial officer to be an oath of office. A building a code official in the state of Michigan is not an officer either of the legislature, executive branch, or the judicial branch. And there is no state statute that I am aware of that requires a building code official to be to take an oath of office. And I know the Michigan Township Association backs that up.
Mr. Monafield, you can step down. I'll accept this for filing. We'll set it for a ruling. Again, I got it like 3 minutes ago. I haven't read it. I'll make a ruling on it on October 15th at 1:30. You may proceed with your motion for entry of a default.
Your Honor, based on our motion and the admissions in the verified complaint by having no answer filed, and the additional supplemental testimony given here by Lance Monafield today, I move for admission of the default judgment and permanent injunction that was submitted with the township's motion and brief in support of that motion.
I was looking for the order. As I indicated, these are circuit court pleadings and their on-base system is different than mine. Do you have a copy of that order with you?
I do, Your Honor. I have an extra copy of the default judgment.
I got a copy of the August 29th order.
And the orders were provided with that proposed judgment when they were served with a motion. It has not changed from that date.
I order. Skip to the order part. It is hereby ordered the plaintiff's verified motion for entry of default dated September 12th, 2025 is granted. The above finding of facts are hereby incorporated and made a part of this judgment. The defendants and their officers, agents, servants, employees, attorneys, assigns, or successors in interest, or anyone involved in participation with the defendants are permanently adjoined from performing any further work on the interior or exterior of this building being constructed on the subject property unless a valid building permit is issued for the building by the building code officials and the stop work orders have been rescinded by plaintiff's building code officials. This is common. This happens all the time. The case right now when someone built a garage, and I don't know how well built it is, but they didn't get a permit. Or they build a house and don't get a permit. You'd be amazed how often that happens. At any rate, I order that. You're enjoined from occupying the building or allowing anyone else to occupy the building unless written authorization is obtained from the plaintiff's building code officials. If an occupancy permit is granted by the plaintiff using the building for anything other than a residential home for which zoning approval was obtained, this prohibits the use of the building by midwives and or pregnant women as a place to give birth in return for compensation, including room rental fees. This does not prohibit a woman from choosing to have a home birth in the building if that building is that woman's principal or permanent residence. Plaintiffs, I'm going to put in here rental room or fees or donation. Plaintiff shall cause a certified copy of this judgment to be recorded in the Officer of Register of Deeds for St. Joseph County within 30 days of the date of the entry of this judgment. No money damages are awarded to Colon Township. Defendants are ordered to pay $304.38 in taxable costs in relation to this motion. They shall be paid within 30 days from the entry of this judgment. The permanent injunctive relief granted in this judgment supersedes the previous injunctive relief granted in the preliminary injunction order dated August 29th. The court retains jurisdiction of the case to enforce the terms of this judgment. From what I saw, that looks like a nice building, and it does look like a medical facility. I'm sure it could be used for something, but it can't be used for a birthing center. I'm going to accept this filing and this filing. I'll ask that the clerk date stamp these and provide a copy of this permanent injunction to the defendants. You have a right to appeal this, but there's a process that is to be followed. This one's a thornier issue. My recommendation is you simply continue your ministry at a different location. A lot of money was spent building this building without a proper permit and without inspections. And we had a case several years ago where a church, they did a large bunch of construction without inspections or permits. they got the girders up to support the church and they didn't match. It was a big mess and eventually it was rectified, but nowhere in the county can you do this, build a building without permits and inspections. So that's my order. I would ask you to go up to unless you want me to just mail it to you, I'd prefer to give you a copy today. Could you guys process this and bring a copy back down for the defendants? All right, you give those to us.
Your Honor,
Yes, Ms. Yoder?
I would like to reappeal both cases.
All right, you can do that, but you can't do it by saying I appeal. Any more than you can say I divorced you 3 times and be divorced. You have a process you have to follow. All right, Mr. Yoder?
Just for the record, I guess, so you know, we had a building permit, we had a foundation permit, we had a zoning permit, a well permit, a septic permit, mechanical permit, and a plumbing permit.
Well, that was my understanding that it started out, it was.
Now, why, if they give me the permits, they had the prints that they could see exactly what that building is. They knew exactly what the square footage is of that building because it's right on the permit. I've still got copies of the permit. Once the building is all built, they say you can't do that. The thing of it is, mister, when we got to the point, my wife says, we got to do something different. She's going to need a new building. I said, all right, you go up, you find out what we need. Because the only place I can put a new building is in 2 acres of woods. So I'm going to have to clear 2 acres of my woods so my wife can put a house in there. I says, I'm not clearing woods before we've got permits. Ain't happening. So they give us all these permits. She talked with Joe from Safe Built and told him what she wants to do. And he told her how to fill out the permits. Okay, so we had the permits. The building is all enclosed. Yes, it's not going to weather from the outside. But all of a sudden they say, oh, you can't do that because you need this and this and this and this. Explain that.
I don't know that I have an explanation. I agree. This was started. You didn't just show up in the dark of night.
It's totally uncalled for.
All right. The problem is they filed the action, the default entered, and now you raise your defense.
We filed personal or special appearance papers on every court case that was filed.
So you have this concept of oath of office and special appearance papers. The court didn't accept those as a pleading. As again, you need legal help, real legal help, somebody with a license and some understanding. And I would encourage you to continue to get it. You've got what looks like the bones of a very nice building there, but you can't use it for the intended purpose. And you're right. They let you start this, and then somewhere along the line, the wheels fell off.
Well, how can they do that?
I don't know, but they just did.
Your
So,
Honor.
all right, we're going to be in recess. This matter is completed. You wait here. They'll bring you a copy of the order. You have a right to appeal it. We're going to have a further hearing on October 15th, where we'll determine what the penalty is, and I'll have an opportunity to review your motion and rule on it. If you want to file anything else, you can file it and schedule for hearing on that date. All right, we'll be in recess. Thank you all for being here. This is a public proceeding, and it's a healthy thing that people can actually
Yes, Your Honor.
I'm gonna hand that up.
What's that?
You have the police report?
I do.
Just circle the date and time on there, will you please, for the offense? And then as soon as you do that, I'm gonna recall the case. All right. Okay, let's go back on record, Mr. Nichol, on James Curtis Yadon Jr., 25I, 415-116, A and B. All right.
Edward Nyko appearing on behalf of Mr. James Yaden Jr., who's present with me.
Mr. Yaden, your name again, sir?
James Yaden.
Sir, your appearance?
Good morning, Your Honor, to you and your staff. Matt Wayne on behalf of Bristol Township.
All right, so it looks like the offense date was August 16th at 18:03, which would be 6:03 p.m. So do you move, does that sound correct to you, Mr. Yadon?
Yes, sir.
Do you want to move to amend the citation to reflect the date of offense as being August 16th of 25 at 8:03 p.m.?
Yes, Your Honor.
I'm sorry, at 6:03 p.m.?
Yes, Your Honor.
You don't have any objection, right, Mr. Nichol?
Is that the time that shows on the police report? Is that where that time is coming from? Because on
Yes.
the original citation, it was 9:02 p.m.
Maybe-
So I didn't see that.
Yeah, they got to be careful. They got to be careful over there. I mean, maybe that's when he issued the citation as opposed to the stop.
Maybe.
So
I think,
anyway,
Sir
any
Benson.
objection to that amendment, making it August 16th at 6:03 p.m.?
I'm just looking at the police report. I just wanted to verify.
Now he's got, 5:59 is when he saw him. Initially.
Right to the write-up, right? 17:59 hours, yes.
Correct. So
We have no objection to the amendment to correct the record of on the citation and or the complaint.
So Lisa, so there's no confusion. We want to go back and amend everything with the Secretary of State so they don't think there's two different drunk drivings 2 days apart.
Yep,
So
I'll take care of that today.
Okay, so sir, do you understand everything I've said so far?
Yes, sir.
You understand the possible penalties?
Yes, sir.
You understand your rights?
Yes, sir.
All right, now I'm going to ask you to, again, you're the charge of operating while intoxicated. How do you plead?
Guilty.
On August 16th of 25, were you operating a motor vehicle on Groseal Parkway near Meridian and Groseal at 6:03 p.m.?
Yes, sir.
And did you drink alcohol prior to that? And if so, what and how much?
I obviously drank too much.
Okay, I know, but what were you drinking and about how many?
I was drinking vodka and cranberry juice, and I approximately had 6, I think.
Okay, do you think your ability to operate the vehicle was significantly and materially affected due to the consumption of the alcohol?
Yes, sir, I do.
Okay, why were you pulled over by the police? Do you know?
He said I was speeding.
You think you were speeding?
I more than likely was. I was driving my wife's vehicle, which I'm not used to driving.
Okay, and you think you were speeding at least in part because of your alcohol consumption?
Yes, probably.
And Mr. Nichol, do you stipulate that the blood or breath draw, was this a blood test or a breath test?
Was an intoxilizer breath test.
Right.
It would stipulate to 0.20.
Okay, good enough. Are you on probation or parole, Mr. Yadon?
No, sir.
Anybody force you to plead guilty or promise anything to induce you to plead guilty?
No, sir.
Okay, I'm going to accept your guilty plea to operating while intoxicated. Pursuant to stipulation, I'm going to go ahead and dismiss the super drunk charge. I'm going to refer you for a screening and assessment. So you can come up here today, you'll fill out a questionnaire and be interviewed, and then you'll come back for sentence, okay? We'll give you a sentence date now. And he's been going to the AA at least once a week, Mr. Nykel. You've seen it at least
I have
twice. He's gone.
Yes, he's attended 3 times, actually.
Okay, good enough. So we'll give you a sentence date and then you come up here and fill out the questionnaire with probation. You go right to the probation department and then you'll be interviewed and then they'll prepare a report and recommendation. You'll have an opportunity to review with your lawyer before sentencing. What do you have sentence wise, Lisa?
October 8th at 8:30.
Is that good with you? Mr. Nykel?
Just give me a second here.
Sure.
October 8th. Is a Wednesday at 8:30. Looks good for me. Yes.
Oh,
And you
that's
as
what
well.
we'll schedule.
Yeah,
Mr.
looks
Yeager,
good.
you ever been in trouble before, sir?
No, sir.
Okay. All right. Well, good luck to you. Come on up here and today and go right to probation. When you walk through the doors, go to your right. Okay?
Yes, sir.
And I didn't get the time on that on October 8th. What was that?
8:30.
Okay, great. Thank you.
Okay. Thank you. Thanks, Mr. Wayne. Thank you.
Thank you, Your Honor.
Do you guys have anything else?
I'll leave one other matter, Your Honor, yes.
Okay. Okay, I'll just wait for you. Ms. Foley Carter, do you have anything else ready right now or?
Nothing, Your Honor. I believe Mr. Baldwin's talking to at least one person right now.
Okay. Sir, I'm sorry. What is your name back there?
Scott, Your Honor.
What are you here on?
Zoning and civil infraction, zoning. So last matter, Your Honor.
Okay, so you're gonna go talk to them now?
I'd like to talk to you.
What is it set for, gentlemen?
I don't even know. I don't even know the name on it. What's the name? Aspen and ASTLM.
It's a number.
Yeah, he never checked in with me, so I didn't know it was here.
All
It's
right,
set for a formal hearing.
yeah, so we're set for a formal, so either you guys decide to resolve it or we'll go forward. What is the charge?
Yeah, it's a building department. Insured. Yeah. Permitted use, I believe.
Are they here?
Yes, sir.
Okay. Well, you guys, you want to go talk, see if you can resolve it?
It can't be resolved.
Well, why not?
It's a black or white issue. It's the interpretation of the zoning. ordinance.
All right, well, if you guys can't resolve it, I'm ready to go.
We'll get him on the bill, Your Honor. Thank you.
Okay? Tell you what, I'm gonna get off here for a few minutes and we should be able to handle this right then, okay?
Yeah.
I'll be right back to you.
Nice to be. Next. Back session.
Fine. Did you have the file up here, Council? Yeah, but this guy.
Judge, the file was.
All right, people against. Scott Aston, file number 5I-82573. Everybody's name?
Good morning, Your Honor. Matthew Wayne, again, from Rosehill Township. Scott Aston, defendant.
Okay, so we went in chambers. You guys asked to speak to me. Prosecutor handed me a couple of things that apparently you didn't have, Mr. Aston, so I had them copied for you because I inquired of him as to whether or not he provided these to you. And I'm going to hand you plaintiff defendant Isaac Aknana's LLC's response to plaintiff Rosehill Township's motion for summary. That was in circuit court in front of Judge Gillis Jr. And then also plaintiff's reply to defendant's response to motion for summary disposition. So I'm gonna hand you those down. And you should have everything. We talked about the kids. You have those now, right, sir? Just double check. So you have, so that packet, you have everything, right? Okay, so here's what I'm gonna do. We talked about it. Parties to brief the issue. We're gonna adjourn this for 4 weeks, Lisa. To October what?
October 22nd at 8:30.
Now, so plaintiff or prosecutor to file brief. And again, outlining why the defendant is responsible of the section that's cited in the citation. And again, this all has to do with his ability to have short-term rentals. So I'm going to give you until October the 4th. Defendant's response due.
So your honor, is October the 4th is a Saturday?
October 6th. Defendant's response due by October 17th. Okay? Did I cover everything here?
You said the 17th for
The defendant's response. And if you have a reply to a response to his, or either one of you do, you can file brief all day long as far as I'm concerned. I could care less. I'll read them. Okay? I'm going to hand the rest of this, Lisa. I want to keep the rest of this with this file. I don't know if it'll fit in this file jacket. I guess it will for now. You can go down the hall. They'll give you your new notice. Okay? Any questions, Mr. Aston? Anything else, Mr. Wayne?
No, thank you, your honor.
Thank you both.
Thank you, staff. Say hello.
Oh, yeah. I just talked to him the other day.
It's the second daughter is law school right now.
Right, I know she is. That's great. Good.
Thank you.
Thanks. Good to see you. It's a quiet day today.
It is. I think it's still on.
Antoine Leishon Torrance, 25B148681 A and B.
Hi. Good morning, Your Honor. For the record, House Counsel, Mike Baldwin for Mr. Torrance. Sir, if you can just please state your name.
Antoine Leishon Torrance. So he's going to plead on the A file, possession of controlled substance, the defective equipment charge, file B, count 2 to be dismissed. True?
Yes, Judge, and I do believe that he's got perhaps maybe 60 days jail credit.
Is that what you want to do, Mr. Torrance?
Yes, sir.
You plead guilty here, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that? You got to keep your voice up.
Yes, sir.
Did you sign, read, and understand and advice of rights?
Yes.
Plead guilty, you'll be giving up all those rights. And there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, to the charge of possession of controlled substance, how do you plead? Were you in Brownstown Township on Telegraph near Bridgewood in Brownstown, May the 29th of 25?
Yeah.
Were you in possession of crack cocaine?
Yeah.
And how much did you have?
The report says four small rocks, Judge. I think we're less than a gram.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No, sir.
Plea is accepted, defective equipment's dismissed. enlighten me as to how he has 60 days credit.
He was on a bond violation of another case, and I believe that
Well, that,
this was running concurrent while he was sitting in jail from May through July. But you know, it's interesting because I think he was arraigned on July 2nd.
he wasn't arraigned on this until August 27th.
I thought I saw July 2nd.
July 2nd, he was supposed to be here. We issued a show cause when he failed to appear. I issued a warrant on July 16 when he failed to appear.
I was in county jail then. And that's why.
And then he posted something on July 30.
Yeah, and that's when I got out, and then they said I had to, and then I had to pay a bond here. And then that's why I wasn't in court here.
I'm going to order a screening and assessment. Give me a new sentence date, Lisa.
October 8th at 8:30.
October 8th at 8:30 will be your sentence date. You're going to have to provide me with some kind of proof. I don't think he has one day coming in on this. I'm not saying I'm sending him to jail, not sending him to jail.
He wants to get some more information about who you are, what he said. He needs to be able to look at more probation, not today, but tomorrow.
This is strange.
He was just released yesterday because I sent a writ over to the jail a couple days ago when his family called.
I don't even see where I set bond conditions on this. What is going on this? Can you enlighten me, Lisa?
Well, let me check.
I think he got a surety bond.
It looks like the bond or the warrant was canceled on July 30th because he posted. Then a surety bond came in.
But he wasn't even arraigned until August the 27th, it looks like.
Yeah, August 27th.
And I just continued the bond. Look, no alcohol, no illegal drugs. You're not to purchase, possess, or consume any of those. Do you understand that?
Yes.
I won't require NA. I'm going to sentence you quickly and we'll go from there. And then you can come in here and tell me how he's entitled to credit for time served or 60 days. I don't think he is. We'll go from there and have a good day. Thank you.
Thank you very much.
Raheem Shah, 25B149042.
Judge, we need to know October 8th. If you go to the front desk, they'll print you a notice. Okay. And then you'll have something in there. If you get confused, come back in here. Judge, for the record, House Counsel Attorney Mike Baldwin on behalf of Raheem Shah, Circle Municipal State Legal. Raheem Shah.
So he's going to plead to careless driving. You're going to dismiss to leave the scene. True?
Yes, yes. Yeah, there is no restitution or claim of restitution being made.
To the charge of careless driving, and that's 3 points. How do you plead? Responsible or not responsible?
Responsible.
Plea is accepted. The original charge of leave the scene is dismissed. That's 3 points, $235.
Well, hang on a second. All right, here's what I'm gonna do, and then I'll answer your question. Okay. I'll order restitution in the amount of $3,029.08. Okay. And then my next, when you say, do you have to pay the whole amount? What are you asking?
Well, I've been advised that this is not a trial, and I need to get my paperwork, please.
Okay, go ahead.
Due to the fact that I'm the only person that was there, she was driving a Cadillac. She wasn't driving the vehicle that has been stated in the police report. Also, she did not wait for the officer to show up so the officer could look at her vehicle. Anything could have happened to her vehicle from the time that she left Wendy's and from the time she got home. And then I didn't receive a phone call from the officer till 4 or 5 hours later, stating the fact that that this had happened. And all she had to do was send pictures over. And that justified the fact that I hit her car. When I didn't, I would have stayed if I hit her car. It's what car insurance is for.
Hold on a second, ma'am. Okay, can we? Go ahead.
Sitting on the drive-through, there's just no way I could have done that kind of damage. You're sitting still. It would have affected.
Ma'am, let me just stop you. And I know you got something you want to tell me. But there was, and I read it, there was a no contest plea to these charges.
Right.
And now you're disputing them?
I took that because I was not informed that I had to pay restitution. I took that because that was the cheapest way out.
So, okay. Go ahead.
That's okay. Thank you very much for your time.
Is there anything else? I mean,
there's no proof of anything and it doesn't make sense to me. It really doesn't. I mean, the officer wouldn't look at my vehicle. I offered to bring it in, like I've been cooperative.
Right. Well, but understand that the only thing that I'm going to know when I'm looking at this, because it was a no contest plea, is what's contained in the report. And as part of a no contest plea, I accept what's in the report is true in terms of making a finding. Now, where you got the information that restitution may not happen, I don't know, and I'm not getting into that. I will just say that when something like this happens, the issue of restitution, a lot of it is statutory, it just occurs, okay? So going back to your initial question of the payment of the restitution. Now, how can you pay that? Let me ask you that first.
I can't. I don't have a job. But, it's the law. I've always followed the law, never been in trouble with the law. So, I mean, I just thought maybe you would take in consideration the fact that there's no proof. I mean, she just sends pictures over.
Okay. So here's the thing that you have to understand about this, and that's why I keep going back to the no contest plea. Once you enter that plea, then Miss Miller basically becomes a crime victim. And pursuant to the statutes, then she's entitled to restitution. That's a simplified version. Okay. So in essence, she's entitled to be made whole. Yeah. In terms of restitution, and now that it's been stipulated to, I don't know that there's much the court can do. It really becomes an issue of how it gets paid. And it's also so that you know, because I know you've been in the courtroom with other cases, I'll try to work with people, but I have less flexibility with the issue of restitution. In fact, in a lot of ways, I have none. I can set it up so that it's paid over time, certainly, but I can't waive any part of it. My hands are tied in that respect.
So I needed to go to court and prove all that stuff in order to avoid paying this then, right? That's what I needed to have done. Going to trial.
Ma'am, I can't answer that.
I know, I'm sorry. I'm not getting any answers, so I'm coming to you.
Because there are so many, the reason I can't answer it is because there are so many reasons why somebody may not go to trial or goes to trial. There are a whole lot of different considerations that play into that. So If it were a simple yes or no and I had an opinion about it, then I'd tell you, but I can't, in all honesty, say that.
Okay.
Okay,
Well, thank you for listening.
not a problem. So in regard to the restitution, do you know how you're gonna get that paid or how you're gonna pay it?
I'll figure it out.
Okay, so, but I got you. But I need to sort of put something on it to say how you're going to do it.
It's $50 a month, according to my probation right now.
Pardon?
$50 a month.
$50 a month is what your payment plan is to us.
Yes.
Your Honor, that's for the fines and costs.
Fines and costs. All right, why don't we do it this way? Because you say you're not working right
No, I have a job, but I just applied for it and it takes another month to see if I get it. So.
Got it. Okay. So, Ms. Polero, why don't we do this? Have you made any of the $50 payments yet?
Yes, I've already made 125.
That was on
another
the
50.
date of sentencing, right?
Right.
Okay. And then, so then your next payment was going to be the 50.
Right. I'll make that today when I leave.
Okay. Are you making that in cash?
No.
Okay. So here's what I'm going to do. Let's set. You have her review is February 24th of 2027. All right, so here's what I want. The $50, so you'll need to pay it in cash, right?
Like come in here and actually pay
And
it?
actually pay it.
Okay.
The reason I'm gonna you have to do that is because I'm gonna have what you can pay in terms of the $50 go to the restitution.
Oh, okay.
Okay, but I can't do, if you were gonna pay it on a card, I can't do it that way.
Okay.
Okay, so it's gotta be cash that you come in and pay.
Okay.
All right, so I realize you set up a payment plan. She's now got this balance. It's gonna be $50 per month until probation tells you otherwise. If you get employed, then it might be something else.
Okay.
Got it?
Yep.
And you just have to pay that in cash. It's go to the restitution and then be paid over so that balance can go down. Make some sense to you?
Yes.
All right. And then we'll do it that way. So I've ordered it. It's payable through the court in accordance with what I've said and at the direction of probation. Okay. All right. Thank you.
And Your Honor, lastly, I just want to make sure that my appearance is being removed as attorney of record from this point forward.
File an order requesting that you be removed this attorney of record as one would do at the conclusion of a certain point, and the court will sign it. Thank you.
Thank you.
What is that?
It's 12 o'clock. Technically, it's only 10 cases.
Why is Paige looking at me that way?
10 cases.
She's ready to go.
They're all show causes.
They're all show causes.
Yeah.
Okay, let's just do it. Court does call the case of the people versus Ashley Beaupre.
Welcome on behalf of Ms. Beaupre, who should be present via Zoom. Ma'am,
He is, I think.
can you please state your name for the court?
Ashley Beaupre.
Okay.
Your Honor, this attorney spoke to Ms. Beaupre. It is my understanding that she is requesting a $50 a month payment plan. She would be able to pay more if possible. She is now back to work, going to school and working on getting her license. So she's asking for a $50 monthly payment plan.
Driver's license?
I think so. That's
Okay.
not specified in the note.
All right. And Ms. Beaupre, when would you like to begin those payments?
I can start this week.
All right, well, why don't we do it this way? Give you a little bit of a breather. $50 per month beginning October 1st. Okay? Not
Sounds
much of
good.
one. All right. And then $50 per month thereafter until it's paid. All right, ma'am. Thank you.
Good to see you.
Good to see you too. You're doing well, I take it.
Yep, I'm working as a vet tech and going to school, so
So you're working as a vet tech. What are we going to school for?
to be a licensed vet tech.
Ah, fantastic.
Yeah. My mom says she
All right.
watches you all the time and she misses you, so.
Okay. Give my best, please. All
I
right.
will.
You take
Have a
care of
great day.
yourself.
You too.
All right. Court calls the case, People versus Davion Copeland.
There's no problem, Your Honor.
Davion Copeland, how much is that?
$3,300, and I apologize. He apparently was in Zoom earlier, but he is not.
Oh, he was?
Yeah.
Okay. And then I'll adjourn this out to my October 8th, is it?
Yep.
October 8th, 2025, 9 a.m. Court calls the case of the People versus Jarrell Davis.
Public Defender Natalie Pate with and on behalf of Mr. Davis, who is present via Zoom. Sir, can you let me state your name for the court?
I think he's trying to unmute.
Okay, I'm here.
Okay, state your name.
Jarrell Davis.
All right.
Thank you, Your Honors. I believe his balance is currently, Mr. Davis's balance is currently $370. He did make a $50 payment this morning, bringing his balance down to that number. I believe we'd be asking for adjournment of the show cause, but he stated to me he's trying to get this paid off in the next couple of months.
Okay. Is that right, sir?
Yes.
Okay. Why don't you give me my November date, 12th?
Yes.
I'll adjourn this matter to November 12th, 2025, 9 a.m. And I'm going to indicate defendant to pay balance.
Okay.
So get it paid off. All right?
All right, thank you.
Thank you.
Thanks, Davis.
Court calls case People versus Cesarius Edwards.
Public Defender Natalie Pate with and on behalf of Mr. Edwards, who should be present via Zoom.
Yes.
Awesome. Mr. Edwards, can you please state your name for the court?
Cesarius Edwards.
All right.
Thank you, Your Honor. I did speak with Mr. Edwards regarding this. He's asking for a $25 per month payment. He stated to me that he currently has an FOC matter going on. However, he does provide for his kids full time. So I would be asking for that payment plan.
Is that right, sir?
Yes, sir.
All right. So when can you begin the 25 per month?
Probably next Friday when I get paid.
Okay. So here's what I'll do. Pay $25 per month beginning October 1 and then 25 per month until paid in full, okay?
All right.
I'll do it that way for right now. All right.
All right.
Thank you.
Yep, thank you.
Court calls case People versus Mohammed Farah.
Natalie Pate for Mr. Farha, who is not present, Your Honor. He states to me he's currently on his way and was supposed to be here about around 1. He does have, so he has an outstanding warrant in a felony non-support case. He did attempt to take care of that, but was instructed that he needed to turn himself into the jail before he'd be arraigned on that. That being said, he was going to come here in person today.
My notes don't indicate that. I never said anything about that to you at the plea.
No.
Probation's not recommending, probation is not recommending community control. I don't know where you got getting
that.
that
Was the
from.
understanding I thought I had. Guess I'm confused, sir.
Yeah, Mr.
I
Tipton,
apologize.
you have been on supervision with this court just last year.
I understand. Your Honor.
You failed to complete recovery court. You got kicked out of that, which is very hard to do. And according to my notes, and this note is from, let me get the preliminary. January of this year, you had a preliminary probation violation on that case, which you failed to appear at and had to issue a warrant for your arrest. December of 16, you were positive for methamphetamines, amphetamines, and THC. You failed to report for office visits in December and January. I mean, I look back over your prior record, which is voluminous, and I can't see any occasion where you successfully completed probation or community control. Is that accurate?
Yes, sir. That's it.
And your record's long. I mean, this is not, and then you literally just get unsuccessfully terminated from community control from this court, and you go and you commit another act of violence. I don't know how you can expect me to continue to just turn a blind eye to your conduct. I mean, you come up, you seem like you're a smart guy. You have all the right words, but your actions don't match your words. And unfortunately for you, that means something here. The court has considered the statements made here today, the pre-sentence investigation, the purposes and principles of sentencing, the relevance, seriousness, and recidivism factors. The court does find that you are not amenable to community control and that prison is necessary to fulfill the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. Probation would not adequately punish you and would demean what happened in this case, and that prison is necessary because of your numerous failures to respond to previous community control sanctions. So the court is going to order you to serve 12 months in prison. You have 111 days jail time credit. Court finds that you're indigent for the purpose of any fines, cost, or other financial sanctions. You're also subject to a discretionary period of post-release control. Upon your release, the adult parole authority may supervise you for up to 2 years. If you violate that supervision, you can be returned to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer. That time would run consecutive to any additional prison time that you get sentenced to. There may be opportunities for you to receive up to 1 day per month for participating in certain education, vocation, or other programs sponsored by the Department of Corrections. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I will appoint one for you at no cost. Ms. Tranter, is there anything else?
Nothing further.
Mr. Staten?
No.
All right, that's all.
Looking for the podium, Your Honor.
Yes, please. All right, this is case number 25-CR-42361, the State of Ohio versus Kalia Carney. Ms. Carney is before the court with her counsel, Mr. Staten, Ms. Nicholson, on behalf of the State of Ohio. We're here on the defendant's request for a bond modification. Is that correct?
Yes.
All right, Mr. Staten.
Your Honor, my client has been on electronic home monitoring. We believe she's been compliant and successful with that thus far. I brought this issue to the court's attention earlier. There was an uncertainty or a disagreement between the parties as to whether or not she had been calling in when she needed to go to doctor's appointments and other functions. I believe that's been cleared up between her and her probation officer. She has been calling in as necessary. She does have a number of appointments and things with her small child, and she's expecting a second child, so she has prenatal care and the like. So we'd ask the court to consider removing that specific requirement from her pretrial release. She has appeared at all court appearances, appeared in my office to meet with me, and has been otherwise compliant.
Ms. Tranter?
It's me, Your Honor.
Oh, I'm sorry. I didn't even look
I'm
at
here.
Ms. Nicholson. Sorry.
We understand she has no criminal history. She, I think, did have some issues initially. I believe at our first pretrial, the report from Community Corrections was she was pretty much leaving whenever she wanted to leave. This is a felony of the second degree, but we will defer to court.
What is this currently set for?
It's currently set for a status after her co-defendant's trial.
Okay. Anything from probation?
No, Your Honor, I would just like to indicate that Ms. Carney has been doing a lot better since our last pretrial. We had a bit of a discussion on communication and just going to do what she was permitted to do and nothing else. She has been a lot better in that aspect and has been in contact with me, so that is a plus.
Did she test today?
She did, Your Honor, and she was negative.
Okay. All right, Ms. Carney, the court will modify the terms and conditions of your bond to remove the electronic monitor today. You need to stay in contact with your attorney.
Okay.
And I don't know, again, I think that that was intentionally, as far as what's going on with your co-defendant and all of that. Obviously, is this a mandatory?
This is mandatory time, and I'll speak with Mr. Staten, but I don't want to talk about our
I
discussions
understand.
on the record.
I understand. Okay. All right. Stay in contact with Mr. Staten. Appear when you're ordered to appear. Okay?
Okay.
Thank you.
Thank you.
She's on pretrial supervision.
Sounds good, Your Honor. Thank you.
Does she have to go back in there?
Yes, stick around outside.
Okay.
to both deal with this as well as then likely be taken into custody on the warrant or turn himself in. Obviously, he's not arrived from Flat Rock yet. I did advise him if this case is called, he was not there by then, I would tell him so, and that he should then just turn himself in on the FNS cases.
Yeah, okay, so I think I followed you. He was coming down on, I have it for me, so he was
Oh, okay.
coming down on his child support case to turn himself in.
Yes, but he was scheduled for a show cause in this misdemeanor case as well. So I
Right.
told him to appear in person, that hopefully the arraignment could take place as well in the show cause, and that.
Right.
Yes,
Okay, so,
not here yet, but he's on his way. So he says.
okay, yeah, right, I got you. I'm just, do you know, because it's a child support case, whether he was looking to oh my goodness. Okay, that's what he owes. Okay. So give me about 25% of 26,000.
65.
Okay, so that you know, I don't know if you would have apprised him of this. That would be the bond amount if I did the 25%.
Yes, Your Honor. Yes.
Does he know whether or not he's gonna be able to pay that?
Last we spoke regarding that, it is my understanding, no, Your Honor. Unless something has changed in his circumstance, I don't anticipate he would be posting that bond.
Okay, so here's what I'll do. You're gonna be around this afternoon, Miss Faye?
Yes.
Okay, so what I'll do is I'll pass, what time is it now?
It's 1 o'clock.
Okay, so it's just 1 o'clock I'm gonna pass both of these, and even if I finish these, we'll wait a little bit. So that then when he comes, since he was gonna try to take care of everything, maybe we can give a quicker PCC date. So that we could, if he's gonna be in. All right, so I'll pass those. Court does call the case People versus Sylvester Holman.
This is Public Defender Natalie Pate for Mr. Holman, Your Honor. I do not believe it's present. Does currently have a balance of $1,245. The phone number I had from previously is now disconnected. I do know that you appeared in person for this violation of probation hearing previously. I would ask for an additional request for the record. I don't have an explanation as to failure to appear during this hearing.
Bench warrant will issue bond 10,000, give 10% privilege. That warrant will issue immediately. Court calls case People versus Keyshawn Jorgensen.
Your Honor, this is a show cause for cost. He does not have counsel. He's not here.
This is show cause for Pentecost. Balance is about
$2,175.
Jorgensen, not present. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000. I'll give a 10% privilege on that. Warrant will issue immediately. Court calls case People versus Anthony Lafredo.
The Public Defender Natalie Pate, present via Zoom. State your name to the court.
He's not here.
Your Honor, I did send him the Zoom information from the voicemail. It's my understanding that the balance is $654. For the record, I request an adjournment.
Bench warrant will issue $7,500, 10% is the amount. That warrant will issue immediately. Just the first one. Court calls the case People versus Darian Rhodes.
The show cause for fines and costs, Your Honor, without counsel, there are $758.
That's 1357.
Yes, sir.
Darian Rhodes. No response. Bench warrant will issue for defendant's failure to appear. Bond is setting amount of $7,500, 10%. That warrant will issue immediately. Here, you can have it. Court does call the case People versus Gary Thomas.
Under Natalie Pink, Mr. Thomas, who may be present via Zoom. Sir, if you're present, can you please unmute and state your name for the court? He's not in Zoom, but he's a family member. Waiting room.
A family member?
Yeah, said they're family. So Your Honor, this one, this was one of Mrs. Kearney's. She did send the Zoom information, but has not had an opportunity to discuss this balance with him. She did receive an email during the docket earlier from his email address. That seemed to think that he might be on the Zoom, but I don't know for sure.
Let him in. Let's. That's her. That's him. Okay. Court calls case People versus Gary Thomas.
Assistant Public Defender Natalie Pink, with on behalf of Mr. Thomas. Mr. Thomas, can you please state your name for the court?
Gary Thomas.
Okay.
Your Honor, I believe we're here for show cause on unpaid fines and costs. I believe Ms. Kearney did reach out to Mr. Thomas. Has not had an opportunity to discuss with him his balance.
I think he owes 905.
Yes.
All right, Mr. Thomas, you owe $905. How are you gonna get that paid?
As soon as I just get out of jail, only been out almost a month, so I'm still looking for work.
Okay, let's do this then, because I think you finally got out, right?
Yeah.
Okay, so I think I knew, and we adjourned it to last time. I'm gonna adjourn you to November 12th, 2025, 9 a.m. I need some money paid. I need some money paid, or you gotta come to me with a plan on how we're getting this done.
Okay.
You hear me?
Yes, sir.
All right, take care. Thank you. Okay. That's that. We'll wait on that. We'll check with you.
He did text me 1 minute ago, Your
Oh,
Honor. So I texted him, told him to come to the courtroom, the judge passed your case. Then he texted me 1 minute ago. I really apologize. 45 minutes ETA. 1 hour, so.
I'll be here.
Sounds great.
Okay.
Awesome.
I mean, he's making an effort to try to get here, so we'll try to deal with it. All right. $800 we would make.
Court draw near, the Honorable Judge Cedric Simpson.
You may be seated. And this juncture, we have no prosecutor, so.
To make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, Your Honor.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you file an appeal, you have a constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one would be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you could not afford a copy of those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
No, Your Honor.
You still want to plead guilty to these charges?
Yes.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, Your Honor.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, Your Honor.
All right, the amended count 1, vehicular assault is a felony of the 4th degree. And that carries a maximum prison sentence of 18 months and a maximum fine of $5,000. Do you understand that?
Yes.
And the amended count 2, aggravated vehicular assault, is